Mentioning upon notice, my lord, one hearing of 2012 primary trial.
Give it.
I'm grateful.
Very unique.
My dear message is up to 2018.
I'm sorry to trouble your lordship.
Yes, sir.
My lord, I'm grateful.
It is of the year
2012.
very good. Any other mentioning? All the list. So one liability after the petition. This court thus finds no merit in the instant writ petition and the same is dismissed.
Your lordship has called the list, Miller. Yes, Miller. I'm sorry, I tender my apology, Miller. The system, Miller, did not allow me to, Miller, address your lordship, Miller. It was beyond my control. May I have the liberty, Miller, to mention a review application of your lordship's order, Miller? My junior is there, Mr. Shubhobroto.
What is the name of your junior?
Mr. Shubhodip Vishwas.
Mr. Biswas is here.
Oh, then, Miller,
What is the matter about? Mr. Biswas is not here.
Oh, I'm sorry, Miller. Then it is my fault. I'm sorry, I tender my apology, Miller.
Why are you mentioning, sir?
Miller, I'm mentioning, Miller, an application for review of your lordship's order, Miller. That is, Miller, passed on, Miller, 17th April 2023. Miller, allowing a revisional application
For
Miller,
inclusion.
For inclusion.
Very good. What's the number? Take down.
Yes. Miller, I will send my junior, Miller. Number is, Miller, number is 31, RBW 319 of 2024. My junior will go and, Miller.
RBW?
RBW, Miller, 319 of 2024.
319 of 2024. Ask your junior to hand over the slip. I said
yes, madam. Deeply obliged. Deeply obliged. Grateful.
Yes, call the list. Next.
I am for the petitioner. This matter has come at my
I am for the private
respondent.
I am for the respondent of section 7.
Why it is listed under the heading to be mentioned?
My lord, for correction in the judgment, my lord. My lord.
একটু খুলে দাও না।
Thank you.
What are the nature of correction, sir?
My lord, kindly come to first page, my lord. First item, my lord, respondent for Holdia municipality.
Yes.
It will be for the Jagadishpur Gram Panchayat, my lord.
So Holdia municipality would be deleted.
Deleted, my lord.
There is no Holdia municipality.
No, there is no. It is the Gram Panchayat, my lord.
এটা কোথায়? ফাইলটা কোথায়? এগুলো কি লিখলো এটা সব? দেখে দেখি কি আছে। হলদিয়া মিউনিসিপালিটি এলো কোথা থেকে? Yes. Jagadishpur Gram Panchayat. Yes.
My lord, advocate's name will be, my lord, is appearing, my lord.
Lordship, the advocate's name will be Mr. Proceedings and Mr. Swapnesh Malik accordingly on behalf of the respondent number 6 and 7. That was mistakenly. Yes, Lordship.
দাওয়াতি করতে ওটা। নিয়ে আসো দেখি লিস্টটা দাও আমাদের। The instant matter, one by one, take down. The instant matter is listed Hmm.
Last line, my lord. The petitioner is the co-sharer of the plot number 522 and also 521. There is two plots. Now, on the 521 and 522 without giving any adherence of the objection.
It was a 521 and 522.
Yes. Just before one line, my lord. Respondents were raising illegal construction over the plots number 521 and 522. In my writ petition, para 1, my lord, I have stated.
Where it has been stated?
My lord, para 1, my lord.
No, paragraph there is no.
Sorry, my lord, para 2, sorry. Paragraph 2, my lord, in my writ petition, page 5, my lord. Five 522, my lord, joint owner of the unpartitioned property.
This is modification of order perhaps.
Construction was going on at 520.
1 and 522, my lord, both the plots. Para 5, it is also stated, my lord. Para 5, my lord.
No, it is not there.
Para 5, my lord.
This cannot be changed.
This is perhaps modification of order.
No, this cannot be changed. Any other correction?
My lord, there is any other correction? Yes,
If there be a typographical error, I can consider.
okay, my lord, kindly come to my lord. Page 3,
Yes.
subpara 4, my Roman 4.
Yes.
My lord, Roman 6, my lord. The said order dated such and such challenged by the private respondent herein by filing an appeal being MAT number 7320. It will be 1278. This is the CAN number. My lord, next page, my lord. Page 4, my lord, bottom.
Oh. Acha. Yes, that is correct. MAT 1278.
Yes, my lord. It will be MAT 127.
Acha, likho in মিস্টার বাসুর কি কেউ এসছেন জুনিয়র স্লিপ দিয়েছেন? হ্যাঁ, কই দেখি কি স্লিপ আছে? Yes, call the list.
Yes, my lord. Item number 3, I'm for the petitioners, my lord. This matter was heard substantially by my lordship yesterday, my lord. The subject matter of the writ petition, it involves forcible acquisition of the
Very
plots.
good. Where is your senior?
Lord, he's on his legs. May I start or recapitulate the facts, my lord?
I don't require recapitulation. Where is he?
He's on his legs, my lord. I may start, my lord. We had substantially concluded our submissions on the
Very good.
last occasion, my lord. The issue, it involves forcible acquisition of certain plots of land, my lord, measuring 7.45
Yes.
acres, my lord.
So,
Admit-
so
Yes.
the contrary. Sorry. So according to you, the railway authority, from the report of the government, I
As-
filed a thing.
As well as the affidavit in opposition, my lord. The state has filed an affidavit in opposition, my lord, where they have annexed the records of the land acquisition proceedings. Over there, my lord, annexure, that LA case number is 9 of 1964-1965, my lord.
So the railway authority is to justify
Yes,
in which capacity
yes.
or by which mode
They have
they are
occupied
occupying
the
the
rest of the
remaining portion of
rest of the portion of the
property.
land. Because, my lord, according to their affidavit in opposition filed by the state, my lord,
Just a minute. If you in opposition on behalf of the point number 6 to 11.
Response. Number 14, my lord. Dark number 14 is there, my lord, at annexure R1, page 9. Kindly see schedule B. But in respect of these 81 decimals, my lord, no compensation was paid. Schedule B, my lordship will find dark number 14. And my lord, in dark number 82, which is there at schedule A, my lord, out of that, my lord, 37 decimals have been acquired. 37 decimals out of 56 decimals have been acquired, for which, my lord, compensation has been paid only for 37 decimals. As per their records, my lord, only these two plots of land have been acquired, and the rest of the plots of land, my lord, our contention has been forcibly acquired by the railways without following any due process of law, as well as granting any compensation.
So far plot number 14 is concerned,
Yes, my lord.
81 decimals of land have been acquired,
Yes.
for which you have been paid compensation. No compensation.
There was no whisper in the affidavit in opposition by both the respondents of railways and also state. both the opposition of the railway respondents as well as state is the same boat. Same. It is also corroborated.
Sir, kindly check whether I have noted it rightly or not.
Yes.
So far, plot number 14 was concerned.
Yes.
81 decimal of land has been acquired. According to you, no compensation paid.
No.
Right?
There was no whisper about of
Very
the
good.
opposition.
So far as plot number 82 is concerned,
Yes.
37 decimal of land has been acquired, for which compensation has been
Yes.
paid.
We have
So
accepted.
far as
Hmm.
plot number 13 is concerned, report.
My lord,
RS plot number.
that is,
Measuring amount 1.47.
yes, there is no such a acquirement, my lord, requisition on this 30.
No acquisition proceeding
No, no,
done.
no, no.
So they are
Only
in
two plots. Only two plots, 82 and 14.
So for the present,
Yes.
in the instant writ petition,
Yes.
we are concerned with which plots?
My lord, that my lord, only page 82, plot number 82
Yes,
and plot number 14, according to their notification.
sir, I understand.
Yeah.
But come to the page number 2 of your come to page number 2 at the report dated
Yes.
7 to 2024.
Yes. That is in my name. That is, there is no such dispute, but that was not acquired. It was out of acquired land. It
But
is in
still
my-
it is in possession of the railway authority.
No, no, no. That is not possession, but they are claiming that this is by way of plantation. They are possessing by way of plantation.
Kindly peruse the
Yes,
first
yes,
paragraph
yes.
of the report, sir. Kindly
Yes.
read.
Yes, as per the RS ROR and RS plot number 13, amounting 1.47 acre is recorded in the name of one Mithu Mistry, son of Nanda Kishore. That is
Your grandparent.
yes.
Then
And RS plot number 337, which is presently possessed, only 337, not this plot. Possessed by the Southeastern Railway in terms of the railway track.
so what is the measurement of the land?
Total measurement 7.45 acres.
No, as per RS ROR,
Yes.
the RS plot number 13 amounting to 1.47 acre,
Yes.
which was recorded in the name of Mithu Mistry
Yes.
at RS Khotiar number 337,
Yes.
which is presently possessed by Southeastern Railway Authority.
Yes.
So the measurement of the land is 1.47.
That is 4. Yes, my lord. 4.4.
So in respect of this, according to you, no acquisition proceeding was started.
Started.
So question of compensation does not
That's
arise.
not arise. Yes.
So any other plot?
Other plot is there. That is in my name. Still is in my name. according to present record of right.
In your name and
Yes,
in your
yes.
possession.
Yes. Possession means, my lord, they are surrounded by the illegally, and I have not get entry.
So what are those plot numbers that are intended to
Yes,
know?
that plot
Which
number.
are subject matter of the instant
Yes.
petition.
My lord, kindly come.
Paragraph 2, page 9.
My lord, paragraph 2,
Paragraph 2 of what?
writ petition, page 19. না, এটা corresponding case হয়েছে না বল।
Paragraph 2 of page 19.
Of my writ petition.
Hmm.
Here,
14 is also.
that I have sub.
Yeah, you will get your chance, sir.
Yes,
Take your
that I have mentioned in the supplementary list, that is omitted inadvertently.
petitioners are lawful owners of the act.
My lord,
Very good. You are owner, but which are the subject matter of the instant petition?
that this plot,
All these plots.
all these plots, but 14 has not been mentioned here inadvertently, that I have supplementary list.
Sir, I have understood.
Yes,
But so far as plot number 22,
yes, 13,
plot number 13.
82 has been acquired to 37 decimals.
Sir,
Yes,
sir,
yes,
sir,
yes,
please.
yes.
Plot number 22, plot number 13.
And-
No, plot number 13 is there. It has been mentioned.
Yes,
And so far as plot number 22 and 225 by 355.
yes.
What is the report of the state?
That is in my favor. That is in my favor.
So plot number
My lord, yes, my lord, kindly come.
22 and 225
Arrest ko tiyan number.
by 355.
Yes,
What? Let me see the report.
my lord, page number 2
Just a minute. Just a minute.
of the report. এটা কোন মরসিংহ কোথা থেকে এসে যায়নি। আমারটা দেখ, ওখানে আছে।
Yes. So for plot number 22 is there is no existence of RS plot number 222 and plot number 225 by 355.
Yes,
The RS plot number corresponds to 60, which is recorded also in the name of Norosingho Bechar, which is also possessed by that railway authority by way of plantation. So RS plot number 22 has now been renumbered as, that is equivalent to LR plot number 60.
yes,
It stands in the name of Norosingho Bechar,
yes. Where from get it, I do not know why.
recorded in the name of Norosingho Bechar.
Yes.
Have you filed any document to show
Yes.
that this property belongs to you?
Yes, my
So-
lord, if your lordships have come to my first of documents is, my lord.
It must have been annexed with the writ petition.
Yes.
Show.
Yes, ma'am. My lord, if your lordships come to my lord, kindly come to page. Yes, now. Page come to annexure P2
Annexure P2
to
of
page
your writ
100
petition.
Yes,
Page number, sir?
101. It is continuing page 102 and thereafter record of rights. Previously it was old record, thereafter it come to the new records, that is in the computerized record. It is also shown in my name. Dag number also changed.
Whoever will get the DUG number?
My lord, it is dag number, my lord. It is this Kotian number, second 1874. That number is not. It is only Kotian number is there.
Kotian will not serve the purpose. You have to prove your at least your
Yes,
possession.
I shall prove it, my lord. Now, my lord, coming.
You don't have any document of title.
Yes, that is my deed of will, that is probated.
Will, probate does not confer title. Probate does not confer title, it is settled. In order to establish your ownership or possession in respect of LR plot number 60, which was previously RS plot number 22.
Yes.
Have you filed any document?
Yes, yes, document.
Show me the document that I intend to
My lords,
see.
my lords, kindly come to Annex P2, that's 103 first.
Yes, sir.
103. Rayati Mitu Mistri, Nandakishore Mistri, Korida, Kharagpur. Rayat Sithiban. That is, plot number is there. My lord. Annex page number 104. 13, 82.
Sir, I am asking about RS plot number 22 or LR plot number 60.
Yes, my lord, I'm coming. That is, all the record of rights is there, my lord.
Sir, I don't want to see all the record of right. You show either your document of title or document of possession in respect of LR plot number 60,
Yes.
equivalent to RS plot number 22.
Yes.
If it is there, it is there. If it is not there, very good. You will get opportunity to correct it.
My lord, title has been come from my grandfather.
Then your grandfather must have a document of title.
Yes.
Show me that document.
That documents, my lord,
It is not there.
near there.
Very good.
It is a 55, 56.
So,
55,
so
56. my
let
lord.
us concentrate with for the present with regard to plot number 14 and plot number 13.
13, 82, my lord. 82. 82
Sir,
was
plot number 82, you have got the compensation.
that is 56 decimal. Out of 56, 37 has been given.
Huh.
But entire land has been possessed by them. That is my case. Drug number 14 is 4.01 acres. Out of 4.01 acres, they have possessed 81 decimals. Total land is, my lord, there are so many plots. Total land is 7.45 acres.
Plot number 82 is 56 acres. 0.56.
Yes.
Compensation paid in respect of 0.37 decimal.
Yes. Rest have been possessed by them.
So in plot number 14, 81 decimal you have grievance. So far as plot number 82 is concerned, it was measuring out 56 decimal, you got 37, you want rest.
Yes.
And so far as plot number 13, that is 1.47 acre, no acquisition made. Right?
Yes. But in the notification, it is very much clear. Schedule B.
So 0.19 you want to get. Very good. Now
Now,
tell us what is their affidavit in opposition? They have stated anything?
Yes, I'm coming. I am coming, my lord. I am coming, my lord. My lord, the affidavit in opposition filed by the, this is my lord.
Respondent number 6 to 11.
6 to 11, yes. That is, my lord, I've already gone through that.
That is the state.
Yes. Page 3, my lord.
That you have shown that not
Yes.
so much that
Yes,
so
yes.
much has been stated.
Yes.
What is the affidavit in opposition of the railway authority
Yes.
with regard to the RS plot number 14, 82 and
Yes, my lord, I'm saying. My lord, if you
RS plot number 13.
Yes, I am coming to, my lord, page of their opposition of the railways. That is page 4, first page 4. That is all government notification, how they have required the, that is paragraph 9, my lord, come.
Just a minute.
Page 5, paragraph 11, they have stated.
Yes.
10 and 11 kindly come. It is pertinent to mention here that in the LA case number 9 of 6465, no plot of land as mentioned by the petitioners in the writ petition except plot number 82 part was involved in the LA case number such and such. It is totally wrong. As per the award of the authorities, the owner of the plot number 82 part with an area of 37 acre is found to be one Mithu Mistri. That is my grandfather, son of Nanda Kishore, village Korida such and such, who received the payment on 27th March 1966 by check number such and such and dated as his land acquisition compensation in award serial number 13 and a Xerox copy of the award number 13 is also annexed by the government of West Bengal under affidavit in opposition 30 January 2015. Petitioner, second paragraph. 11. Petitioners are claiming as owner of the land being 22, 13, 82, 2225, 335 of the jail number such and such, whereas petitioners are not recorded as the owners as aforesaid plots as per searching report from the net in the official website of the Director of Land Records and the Survey West Bengal. Petitioners are not entitled for asking any review. It is totally wrong, my lord. Still, it is in my name. They have annexed this in their report. In their report, they are stating that I am the owner. On the other hand, opposition, they have said that I am not the owner. Paragraph 11, my lord. I am also giving the rent up to 2008. Thereafter, they stopped accepted the rent. It is also very unfortunate, my lord, on the part of the state government. All the rent receipt is also there.
No, it is the affidavit of opposition of the railway authority.
Yes, but they have come to from the official records of the state government.
Very good.
My lord, a plot-wise chart showing the name of the plot holders as recorded in the state documents. That is their documents. Where from they get it? All those documents, Manohar Dasgupta, Collector of Government, Ramlal Gaur. Where they from get it? I do not
Very
know.
good. Now tell me whether as against the report submitted by the respondent state,
Yes,
the railway authority has filed any exception or not?
I am filed exception, my lord.
You filed exception?
Yes, can railway that file has been by the
So railway authority has not filed exception.
No, no.
So what is the content of your exception?
My lord, I am coming. I am coming to my exception. It is filed. My lord, if your lordships kindly come to the exception filed on behalf of the petitioners against the survey reports dated 5/9/2023 and 7/2/2024 filed on behalf of the respondent number 10 in terms of the solemn order dated. My lord, have your lordships got it? Yes, my lord, kindly come.
No. Apart from the points as raised
Yes.
in course of his argument, have you taken any other point
Yes.
in your exception?
Because they have claiming that I have no owner of the plots, other plots also.
Forget about that. We are on that.
Yes.
Now tell me what is the quantum of the land which has been surrounded by the railway authority?
Yes, that your lordships got it from their own report. They have stated there that it is surrounded by the railway track.
Where from will get that?
Last page of their compliance report, page 46.
Page
And also
46 of
their compliance report.
Oh, I see.
Yes, 7/2/2024.
Page 46.
Yes, 46.
53, 44,
Last page, my
45.
lord.
Yes.
My lord,
Kindly place.
ভিত্তিতে অদ্য 6/2/24 তারিখে মৌজা মথুরাকাটি খাস জঙ্গল জেল নাম্বার সাচ এন্ড সাচ আরএস দাগ নাম্বার 13/82/22 বাই সাচ এন্ড সাচ 14 দাগগুলি সরজমে তদন্ত যৌথ তদন্তে প্রকাশিত বিবাদীয় উপরোক্ত জায়গাগুলি বর্তমানে রেল লাইন যাহা মৌজা নকশায় চিহ্নিত করা আছে তাহা 3টি রেল লাইনের মধ্যস্থলে অবস্থিত, যাহা বর্তমানে এসআর এর তরফ থেকে গাছ লাগানো আছে। They have admitted how they can come all these plots surrounding railway track. Now I can access to my land also.
13, 82.
Yes, 22 by
14.
44669.
20. So those are all covered.
All covered.
And so far as 22/496, it belongs to whom?
That is why they have not mentioned here, but it is come.
No, it is covered. It is covered.
Yes.
So basically, we are concerned about 1482 13 plot number 22, which is equivalent to RS plot number 60. This much. Now tell me, what is your prayer? So far as the land which has been acquired, but no compensation has been paid.
No.
And what is your prayer with regard to the land which has been which has not been acquired, even it is possession of the railway authority?
Yes.
What is your prayer?
My lord, kindly see the prayers. The writ petition, I am coming. My lord,
For directing them to take steps for acquisition, land acquisition.
yes, otherwise it cannot be, I cannot get entry.
So give me the provision, give me the statute. So in the event they intend to, if this court directs
Yes.
to initiate a proceeding for acquisition, under which act it will start?
Because my lord, they have himself admitted it is all railway tracks.
Sir, come to the my
Yes,
question, sir.
So admission is there.
If this court allows your prayer,
Yes.
according to you, under which provision of law the acquisition proceeding will start?
My lord, I'm coming, my lord.
Under the new act or under the old act?
Because now it is come to the new act, my lord. Because so far after 2013 act.
So old act has been repealed.
Repealed.
Show me the provisions of the new act.
That so far my
You
prayer
do
is
not make yourself ready yesterday night.
my lord, something has been disturbed. My determination of value of things attached to the lands, because my valuable trees has been cut down.
Give me the book. Give me
Yes,
the
sir,
book.
that is the determination of the
বইটা দাও।
amount of compensation.
ওগুলো ওরা পড়ে না এলে তো মহা বিপদ।
27 paragraph annex section 27 and 29, also 30.
So they are to act in accordance with the chapter 4 of the act, which says notification and acquisition. Very good. Now tell me that you have stated that in your read petition you have practically forgotten to mention with regard to plot number 14.
Yes, that
How
I-
it has been incorporated?
in the supplementary.
Very good. Take your seat now. Who will start answer?
My lord, I am for the state.
Very good.
First of all, my lord, I am, my lord, raising the point of maintainability of the writ petition
Why?
because the land acquisition proceeding in respect of 14 and 82 in the year of 1965. It has completed, rightly, wrongly, he has to challenge within a due span of time. This is the, my lord, settled law.
Sir, come to your report.
My lord, in my
Sir,
report-
come to your report.
Yes.
Page 2.
Yes,
So far
and
as
this is the facts.
just a minute, sir. So
This
far as come to the second point.
My lord,
Read out.
the arrest plot number 13.
Yes.
Now, Sachana is recorded in the name of Bichu Mistry, one Nandakishore.
No, sir. Read. Don't skip.
My lord.
Every single word is very important.
Yes. As per RS RO1, RS plot number 13, amount.
Sir, I requested you to read the second point first. As artist plot number 82.
82, yes. My lord. RS 82 amounting to 56 acre
Huh.
is recorded in the name of the Mitu Mistry, son of Nandakishore Mistry. RS question number 7 is presently possessed by the Southeastern Railway Authority in terms of railway track.
So it is an admitted position
Yes,
that compensation paid in respect of 37 decimal.
37 decimal.
So no acquisition has been made
In respect
for
of the rest of the part.
in respect of 0.19 acre of land.
My lord, 56.
So question of acquisition does not arise.
56, my lord, 37. That means
19.
huh?
19.
19 years.
So 0.19 acre has not been acquired.
Not acquired, but
So-
so the fact, my lord, in the year 1965. Now in the year 2014.
Sir, your report
My lord, my report
shows that the railway authority is in excess possession,
my lord,
which is according to your report stands in the name of the
if your
writ
lordship
petitioner.
kindly, if your lordship kindly come page 16 of the report, the
Yes.
railway has in 2011 everything has been acquired. 1911
Huh.
everything has been acquired. It is the as per railway claim,
Huh.
and they have annexed they have submitted the, my lord, the notifications, but which are.
Sir, forget about their report. I will.
My lord,
I will-
in my report I have.
I'm insisting upon your report
Yes, page
issued by the
16 of-
BLR.
Page 16 of my report.
Page 16. Yes. What is that?
Mal kindly see, my lord, as per the Honorable High Court.
No. This is a letter written to you.
Yes,
Huh.
Block Development Officer.
Huh.
As per Honorable High Court Calcutta's order such and such, under the above, you have been directed to conduct the survey the entire land of the petitioner measuring about 7.45 acres, and also to demarcate 30.037 decimals of land which was acquired by the state government, and the compensation was paid to the petitioners as well the possession of the remaining land on field inspection within 30 days from the date of the honorable court's order.
Sir, I am telling you,
My lord.
this letter is of no use because it says about the notification number, it says about the date, it says about the village or mouja, it says about the area, and it says about land acquired for the purpose. But it does not say about the relevant plot numbers, which is available from your page number 2 of your report.
My lord, in my report, my lord, I have, my lord, disclosed everything.
Everything.
Everything I have disclosed.
Very good. So the court will act according to your report.
According to your report, but
According to your report.
yes, my lord, but the question of maintainability, as has been laid down by the Honorable Supreme Court in different manner.
So, Somiti law.
Yes, first of all, my lord, the page 394, AIR 2011, volume 5, SCC page.
Just a minute. You are for respondent number?
I am for the state 6 to 11.
Respondent numbers 6 to 11.
Fine.
State.
State.
Yes, not first is not maintainable.
My lord,
Your first point is not maintainable.
not maintainable.
Yes. Next,
My lord,
you rely upon, give the citation.
yes, citation is, my lord, 2011, volume 5.
2011, volume 5, SCC.
Yes, page 394, paragraph 17.
Para 17.
Yes. But may I read first? and
Yes,
then-
sir. Yes.
It is true that no limitation has been prescribed for filing a writ petition under Article 226 of the Constitution, but one of the several rules is the self-imposed restraint evolved by the superior courts, is that the High Court will not entertain petitions after long lapse of time because it may adversely affect the settled or crystallized rights of the parties. If the writ petition is filed beyond the period of limitation prescribed for filing civil suit or similar case, the High Court will treat the delay unreasonable and decline to enter the grievance of the petitioner on merit. Here in this case, my lord, there was land acquisition proceeding, there was only 11 years delay.
Sir, very good. ওটাকে এটাকে দিয়ে মার্ক করো, ওই পেজটাকে মার্ক করো। দিন আমাকে।
The next one is, my lord.
Just a minute. We have to relate the judgments with the facts of this case. লাগান। Admittedly, in respect of plot number 14, 81 decimal of land has been acquired, but no compensation has been paid.
My lord, but my point is that
So far as the plot number 82 is concerned, it consists about
yes, my lord,
56 decimal,
my lord, I am
compensation paid in respect of 37
my
decimal.
lord, in my opposition, I have dealt with
And
only
RS
two
plot
plots.
number was no acquisition proceeding made. Despite that,
Yes,
how it will be barred by limitation, sir?
my lord, if your lordship kindly is
A
that,
read petitioners
my lord,
right to
after
get
200
compensation has been.
after 3 generation, 4 generation,
It is because of your fault.
my lord,
It
that
is covered by
may
the
be the
Supreme
fault.
Court, December 22.
Sir, don't jump.
This may, my lord, the land acquisition case is of
এই
1965.
বইটা দাও গো, বইটা দাও।
Land acquisition case of 1969,
Hmm.
65. The proceeding has been concluded.
Very good. Next.
Next is, my lord, 2015-13 SCC page 563. I 560.
সতেরো just a minute, sir.
এটা বইটা হচ্ছে 30, 15. 2015, 13, page 563. My lord,
What is the citation, sir?
2015,
Yes.
volume 13,
Hmm.
page 563. Paragraph 8.
5, 6,
3.
2015, volume 13, SCC 563.
563.
Paragraph
8.
8.
Yes.
What does it say?
My lord, the learned counsel have been for submitted the delay of 17 years and 53 days in filing the present appeal before the court deserves to be condoned. The submission of the delay should not come in the way of granting substantial justice, and the technicality should give way to justice. The court should be liberal in condoning the delay.
So it is against you.
No, court has that it cannot be done after this delay, 17 years delay.
Hmm.
It is also in my favor.
Very good. Give it. Any other points, sir? Except delay?
My lord, in delay, yes, my lord. The 5 judges bench decision.
Very good. Don't unnecessarily burden with the judgment.
No.
I've understood. Any other point?
Any other point? First of all, my lord, kindly see the petition.
Is the it is on the ground of maintainability.
Maintainability
Very
and my lord, 2020, my lord, only one
Maintainability on account of delay.
on account of delay
Very good.
and still claim.
Still
Because, my lord, I am claiming that the acquisition proceeding of 1965-66. My lord, kindly take it note, my lord.
Then what would be your submission in respect of the land which is
My
found
lord,
to be? Sir,
Sir,
please allow me to put my question. Thereafter give you answer. Without hearing my question, how do you expect to answer?
No.
Then what would be your answer in respect of the report as submitted by your officer, wherefrom it reveals that if a substantial portion of a land over a particular plot is found to be in possession of the railway authority, but it has been recorded in the name of the grandfather of the writ petitioner, and no acquisition proceeding has been started. What would be your answer to that?
My lord, practically, my lord, the grandfather of the petitioner had the right to challenge that you cannot take more the land what you have acquired and what you have paid compensation. But this is of year of 1965, and he waited for last 50 years and allowed to give possession to the railway.
State will take the advantage of adverse position.
Well, I am not taking the adverse position.
The state will take the advantage of adverse position.
No. No, my lord. I am not telling that it is the adverse position. My lord, I am only submitting
The state is a welfare state.
100%.
It is for the citizen.
My lord.
Then
But citizen, my lord, what the negligence, the delay of 50 years.
Union of India and the state, they are saying that they are possessing the land of a particular person
My lord,
without acquisition proceeding,
I
and you are saying that I mean adverse poison.
my lord,
yes or no relief. Show me the law, sir. I don't know the research. Really speaking.
I am only submitting in respect of the delay. I am not submitting, my lord, that point of law. I am submitting only the delay. I am submitting
Very
only
good.
the delay. And the last one is, my lord, 2020, volume 8 SCC,
2020, volume 8 SCC.
page 1 to 9,
Yes.
paragraph 3669.
Para?
3669.
Para 3?
366.9.
Say like that. 366.9.
Yes. My lord, his case is that now it will be acquisition in the new year. His prayer, some of the confusing prayer, I will go with that. Confusing pair. But here it is case the section 24(2) of 2013 Act does not give rise to new cause of action to a question the legality of a concluded proceeding of the land acquisition. Section 24 applies to a proceeding pending on the date of enforcement of Section 2013 Act with effect from 1/1/2014.
দেখি কি বলছেন ওটা?
Indore Development Fund. State নয় রেল উপায় করছে আমি উপায় করছি রেল স্টেট কাছে রেল
Yes, sir. Any other?
My lord, page 19 of the writ petition, I have filed the affidavit in opposition on the basis of the writ petition paragraph 2, page 19. Old, in respect of plot number 14 was missing there and it has not been dealt. In respect of plot number 82, I have dealt that 37 has been acquired out of 56. and so the claim of the petitioner can at least be raised only for that 19 decimal. Paragraph 2, page 19, paragraph 2. 14 is missing. An affidavit in opposition has been filed on the basis of the writ petition.
So far, plot number 14 is concerned,
It is missing.
you have not dealt with.
It has not been dealt with.
Acha.
And my lord, in respect of 82, my lord, it is admitted fact that only 37 decimal has been acquired and payment has been made. But in respect of rest 19 decimal nothing has been done.
Yes.
And my lord, kindly come, my lord, my lord, that 14 I have answered. My lord, now page 62 of the writ petition, the prayer.
Yes.
A writ in the nature of mandamus commanding the respondent number 1 to 14 and their officers and subordinates and each one of them to act in accordance with the provisions of the Land Acquisition Act as well, and also the right to fair compensation and transparency in the Land Acquisition, Rehabilitation and Resettlement Act. This simultaneously two acts cannot be, my lord, applied.
Section 24 is the answer.
My lord,
Section 24 of the new act is the answer.
Section 24 can be invoked when the proceedings, the land, no possession has been taken within 5 years
Or no
or
compensation.
no compensation has been given. But here in this case, my lord, in respect of 37, 37 has been given.
And remaining,
And remaining, my lord, in respect of 19, my lord, I have no answer.
that I am saying.
In respect of 19, I have no answer, my lord, that railway authority can reply that.
That, yes. And the railway authority is also duty bound to reply in respect of plot number 13, that is 1.47 acre.
Yes. But
Because it was never the subject matter of any land acquisition proceeding.
land acquisition
And so
proceeding.
far as the plot number 14 is concerned,
14
the report is silent because it has not been dealt with the writ petition. I have understood that.
And my lord, in respect of my lord, the 22, I have said that, my lord, that it is the recorded, my lord, in that is reported, my lord, that
Yes, yes. That cannot be shown. No document can be, no prima facie of the possession, no prima facie document of possession can be shown by the
in favor of a third party.
Very good.
Well, these are the methods.
Very
But in respect of
Thank you very much. Sir,
Ma-
what's your good name?
Lolit Mohan Mahatar.
Yes, Railway Authority.
Uh,
Your respondent numbers?
1 to 5, Lordship.
What's your good name, sir?
Orishit Majumdar. Lordship, I'm being led by Mr. Aturu Banerjee in this matter, Lordship. As I've already indicated this before, Lordship.
You proceed, sir. I cannot wait for anyone.
Lordship, since he is.
Then I shall have to close. Make your submission.
Lordship. so far in respect of the claim of the petitioners, so far in respect of the entire land, that is admeasuring 7.45 acres, Lordship.
Sir, let us come, make it short.
Lordship, absolutely.
Basically, the allegation is in respect of plot number 14,
Lordship,
plot number 82, RS plot number 13, and
Lordship.
RS plot number 22, which is LR plot number 60. So far as plot number 14 is concerned, there is no whisper in the writ petition.
Lordship.
They claim
That
that they have dealt with in a supplementary affidavit. The report is silent because it has not been dealt with.
Lordship.
So far as
Both-
let us recapture it. I will give you
Lordship, Lordship.
I will give you full credit, and at that time I assure you that I shall keep mum.
Lordship.
So far as the plot number 82 is concerned, the 37 decimal has been so far compensation in respect of 37 has been given, but the state could not give any reply in respect of 0.19.
198.
And so far as the RS plot number 13 is concerned, with 1.47, the state says that no acquisition proceeding started ever, but still it is in possession of yours. And so far as the LR plot number 60 is concerned, it is in the name of the one Norosingho. So that goes. What is
Okay.
your competition?
Since what has fallen from your Lordship, I'll address the first issue which my esteemed senior friend for the state has referred to, that there were no proceeding so far in respect of the other plots concerned. In fact, if your Lordship takes up the report filed by the respondent number 10, dated 7th of February 2024, Lordship, page number 16, which my esteemed senior friend was also referring to. The letter which was written by the respondent railway, there, if your Lordship, if for your Lordship's convenience, since the notification which are annexed, appended with this report are slightly illegible, I'll hand over a better copy. These are not absolutely illegible, but these are the best copy I can produce. Lordship. I'll come one by one, Lordship.
Yes.
The first acquisition proceeding in this Mathura-Kati Khasjongol was acquired in the year 1911, Lordship. This is way back prior to the independence, Lordship. How much was acquired? This is 20.946 acres. I'm not talking on air. If your Lordship can kindly comes to page number 6 of that compilation, Lordship. The Gazette notification of 1911, Lordship. Has the Lordship got it? Part 1. The last portion, Lordship. The last portion, it says on 11th of November 1911, it appears that the Lieutenant Governor is counsel that the land is acquired to be taken by railway, by the government at the purpose of the Bengal Nagpur Railway Company. This is, we are talking in the year of 1911, Lordship, when in the part of this country there were total 13 railway companies. Now Indian Railway at this present juncture, after independence from 1955 onwards, all the regional railways have been merged under the Ministry of Railways, and it has formed under the umbrella of Indian Railways, Lordship. Prior to the independence, Lordship, during the imperial government's regime, there were total of 16 railway companies parallelly were running at the regional basis. And during 1911, this particular acquisition of 20.946 acres were acquired for the purpose of Bengal Nagpur Railway, Lordship. Thereafter, if your Lordship can kindly takes up the first page, the second acquisition, which was made on 30th of June 1923.
Next
Again-
page, next page.
No, Lordship, on the first page.
Yes.
The first page, the tabulated.
Yes.
The second acquisition after 1911 on the very self-same village, Moza. It was acquired in the year 1923, June 1923, at measuring 85.39 acres, Lordship. This was also for the settlement of in the Kharagpur area, and your Lordship will find the notification at page number 7, Lordship.
There is no pagination in here.
Lordship, Lordship, just the page after this 1911 notification. Lordship.
In
I can say
1911,
my unqualified
1911 there are 3 notifications.
Lordship, the first is of 1923. On the right hand top, it is 907, Lordship. The last the last portion, if your Lordship takes up, that was acquired on 30th of June 1923, and it was for 85.39
30th
acres,
June,
Lordship.
30th June.
30th of June, Lordship.
Yes.
The last portion, Lordship.
Yes.
Last portion of page number 7, Lordship.
Huh.
In fact, in that particular notification
They have
itself,
not annexed all these documents in this, their opposition, my lord.
Let,
It's
let, them
yeah.
say, let them say what they are saying. They are showing some notification, right? That's all right. So how do you relate the plot numbers with these notifications?
Lordship, relating these notifications with the plot numbers, my respectful submission is this before your Lordship.
Sir, one thing I believe you will accept. I don't know whether you will accept or not. You are the requiring body.
Lordship,
Be that today or at that material time.
Lordship,
So you are the requiring body. And they are the acquiring authority.
Lordship.
So their report says about the details of the plot numbers, about the recording of the names of the landowner in respect of the land, and the quantum of land occupied by the recorded owners, and the mode of use and the nature of land. These are the mainly documents. So what I am on showing these documents, there is an old notification. How do you relate about with regard to the RS plot number or LR plot number? That I intend.
Lordship, my respectful submission is that this particular set of documents, these are the best documents which are at the records of the respond number 1 to 5, Lordship. Since all these documents pertains to 1911 and thereafter, Lordship. So all these acquisitions which happened prior to
Independence.
Prior to independence and prior to the coming of RS plots, Lordship, during when CS plots were there, and prior to that, during that regime, there were areas that were marked by zamindars and that were being acquired.
If there be any acquisition, there must be those records must be lying with the state.
Lordship,
And they have submitted the report on the basis of the report.
Lordship, this is
They say that in respect of this portion of land, compensation has been paid. In respect of this portion of land, no compensation has been paid. They say in respect of this land, you are in possession, but they do not find any record with regard to the acquisition procedure. They say in respect of a particular plot of land, the name of the read petition of the predecessor was not there. One name of the Nishingo was there. They say that in respect of such and such land, acquisition has been made and compensation has been disbursed. So they are the best authority.
Lordship, if they are the best authority, then they are the state authorities are the best authority in so far in respect of judging my acquisitions which happened at that relevant point of time. Lordship?
Definitely on the basis of that, they have submitted
Lordship, but
report.
they have not, the state authorities have not demarcated the areas which were acquired during 1911, two acquisitions which were made during 1923.
That is you can say. For
Lordship-
which the writ petition is not supposed to suffer.
Lordship, but then it has to be, Lordship, kindly appreciate on one fact that in 1923, 341.69 acres were acquired. On
Sir,
the very same
I
year,
understand. But you have to relate those acquisition with the land of the writ petitioner.
Lordship,
It is the grievance of the land for writ petitioner that in respect of certain plots of land, certain portion of the land was acquired, but it was noticed by him that the entire plot has been acquired without is in possession, which has not been acquired by the respondent state authorities.
so then, Lordship,
It is the
in
case
that
of the writ
particular
petitioner that
then what-
without making any acquisition proceeding, you are in possession. That gets some justification.
So what about the acquisition which has been made by the railways, Lordship?
Very good. Any other points, sir?
Lordship, I'll come to that. Lordship, kindly appreciate on a fact that railway has acquired from 1911 onwards. They have acquired a huge plot of land on that particular moja. Until and unless, Lordship,
Railway has not acquired.
railway
Secretary to the
requisitioned-
government of Bengal has acquired.
Yes, railway requisitioned, and on behalf of the requisitioning authority, the state has acquired, Lordship. Now, unless it is not the petitioner's case that nothing was acquired, no acquisition process was done, only in the year 64 and 65, railway has acquired 82, plot number 82 and 14. That is all. But this is not the case. Why we have, Lordship, the purpose behind the order which was passed by the coordinate bench, wherein a joint inspection was directed. The reason for supplying these documents to the state authorities was the reason
The coordinate
to
bench has
also
taken
demarcate.
the coordinate bench has taken right steps to get a clear picture.
Lordship, but if your Lordship,
Have you filed any exception to the report?
no, we have not filed any exception to the report, Lordship. But what my respectful submission is that if the petitioner is trying to assess and wants to see a demarcated portion of 7.45 acres.
No. He does not want demarcation.
Because
He says, start acquisition proceeding and give me the compensation. This
but
much he has.
my respectful submission is that since in that particular moza from 1911 till 1964, Lordship, there has been numerous.
May I have kindly, my lord? There are some content.
Sure. Any other points, sir?
Lordship, from 1911 till 1965, Lordship, there has been numerous acquisitions. My respectful submission is before your Lordship is that during these acquisitions, his part of lands were acquired. The remaining portion or the portion which remained unacquired till 65 was acquired during 1965.
Then how do you justify that? Why the names of the railway authority has not been recorded there?
That the state will have to answer.
That answer you will not give me. Then who will give the answer, sir? I understand your contention that so far as the remaining portion is concerned, it was covered under 2011 notification or such and such. Very good. I understand.
1911, Lordship.
Very good. 1911 or 1923, whatever. There are so many. But why the names of the railway authorities are not recorded? Why it is not in Khotiyar number 1?
Lordship, that is the very purpose. That is the very purpose where I
understand your point.
where I'm submitting that the purpose behind the joint survey was not taken the light of the day, because on one part, when the petitioner is trying to ascertain 7.45 acres, railway is also trying to ascertain the total of almost 500 acres, Lordship, on that very same Musa. If the both acquisitions, if both the specific are not been demarcated, then how come we can come to a reasonable conclusion that 7.45 acres do belongs to the petitioner as of that particular or the predecessors of the petitioner, Lordship. And one more thing, if your Lordship can kindly takes up the affidavit in opposition of the railways, Lordship, respond number 1 to 5.
Yes, any other point?
Lordship, if your Lordship kindly takes up the affidavit in opposition filed by the respondent number 1 to 5. Straight away, I will take your Lordship to paragraph number 9 at page 4, Lordship.
Just a minute. Respond number 1 to 5, no?
Respond number 1 to 5, Lordship. Been affirmed by Shri Khudiram Hansda,
Khudiram Hasda.
Lordship. So, Lordship kindly takes up paragraph number 9 at page 4, Lordship. The petitioner enclosed
Paragraph
Lordship,
number?
paragraph number 9, Lordship,
Yes.
at page 4.
Yes, sir.
Lordship. The petitioner enclosed one will of Shri Mithulal Sharma dated 20th 7 1964 in the said petition, which is nothing but an afterthought because the Calcutta Gazette notification by the government of West Bengal for the acquisition of land had been published on 31st of March 1964. That is prior to the will which has been mentioned, which subsequently, which was the probate was granted in 1994, Lordship. And Lordship, I am relying upon a judgment, the Honorable Apex Court.
Yes.
Reported in 2014 reported in 2014 for Supreme Court cases 108, Lordship. Paragraph number 16 and 17, Lordship.
16 and 17.
17, Lordship. This,
Just a minute, sir.
Lordship. Two 2014 or court cases, one.
Yes, paragraph number 14,
16 and
16
17,
and 17.
Lordship. This is on the doctrine of delay and laches, Lordship. Which this instant writ petitioners have throughout, they have done in that particular manner whatsoever, Lordship. First,
Place paragraph 16 and
Lordship.
17.
Thus, the doctrine of delay and laches should not be lightly brushed aside. A writ court in required to weigh the explanation offered and the acceptability of the same. The court should not bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizen, but simultaneously, it is to keep itself alive of the primary principle that when an aggrieved person without adequate reason approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the list at a belated stage should be entertained or not. Be it noted, delay comes in the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster. For the litigant who knocks at the door of the court, delay reflects inactivity and inactions on the part of the litigant. A litigant who has forgotten the basic norms, namely procrastination,
is the greatest thief of time.
Lordship. Secondly, law does not permit one to sleep and rise like a phoenix. Delay does not bring in hazard and causes injury to the list.
Very good.
Thereafter, 17 also on the same principle, Lordship. Why I am relying upon this judgment is because 1994, admittedly, the probate was granted. And
Probate granted on
1994, Lordship. 11th of August 1994.
just a minute. And writ petition was filed
2014, Lordship. A delay of 10 years, Lordship.
in 2014.
Lordship.
In the writ petition, is there any explanation with regard to the delay?
Nothing. In my respectful submission, nothing has been.
Any other points, sir?
I would conclude by on a note that since these delays, the delays which has tantamounted during the lifetime of the predecessor of the instant writ petitioners, they never approached so far in respect of the acquisitions, or say, I would say, a purported acquisitions which has been claimed in this by way of this writ petition. First point of delay was on the predecessor's account. The second, after Lordship in 64 and 65, when the part land was acquired by acquiring a part of plot 82 and 14, which my esteemed senior friend representing the state has already mentioned that neither the state nor the railway authorities we have dealt in with so far in respect of plot number 14, since that was absent in the writ petition. Admittedly, the will was executed, or the will was dated after the last notification on that, that is on 31st of March 1964, Lordship.
Yes.
So it was purely an afterthought and nothing more than that.
Very good.
Thirdly, after 1994, the grant of probate, they took almost 10 years.
Sir, don't repeat. I've noted your submission. Very good. I should take the stated lawyer at judgment গুলো কোথায় রাখলাম?
My lord, I am submitting one decision, my lord, if your lordship have
Yes, yes. Give it.
already.
উকিল যেটা দিলেন আমাদের রেসপন্ডেন্ট মিস্টার মাহাতা যেটা দিলেন ওটা কোথায় গেল?
On the point of delay as well as the compensation amount. 2020, volume 2 Supreme Court cases 569 marks. Vidyadevi versus State of Himachal Pradesh and others. Paragraph 12.3, 12.6.
Paragraph, sir?
Paragraph 12.3, paragraph 12.2, paragraph 12.6.
12.6. First.
12.3
Yes.
to paragraph 12.6.
12.3 to 12.6.
No.
Those are on right to property, 300A of the Constitution of India. And what about the delay?
And also delay also. Delay, point of delay also.
Which paragraph?
It is start from 12.7. 12.7.
And the delay aspect has been dealt with in 12.11. The point of delay.
So 12.2 to 12.6, then 12.7
to 12.11. The point of delay has been dealt with in 12.11.
Sir, read 12.11 for my satisfaction.
Yes, sir. We are surprised by the plea taken by the state before the High Court that since it has been in continuous possession of the land for over 42 years, it would tantamount to adverse possession.
As said by me.
Yes.
Next,
The state being a welfare state.
as I stated,
Yes. Cannot be permitted to take the plea of adverse possession, which
That
is
is stated.
trespasser.
that I have stated.
Yes. Yes, my lord. My lord,
Take down.
the judgment is also there, my lord, that copy is not.
Very good. Thank you very much. Hearing is
I'm good.
এই কল্যাণ বাবু
Right now, but can we hand over a copy to?
Yes, what is that?
The judgment has been reported in Kayabhai Digambar Puri versus the executive commissioner and others. We don't have it right now. Can we just hand it over to my lord?
Please. Write the petitioner and the case number,
Handing over judgment in the course of the day only, my lord.
but indicating the case number and on behalf of the petitioner.
Yes, he'll just hand over in the course of the day. I think that's-
Yes.
As I indicated yesterday, that the amount, principal amount along with the interest has already been paid by management for the petitioner. Government was took time to get instruction.
Got instruction, receipt. So it can be disposed of.
My lord.
Take down.
But I have already got the documents as well. If my lord kindly please send me the record of this.
Yes.
This is the first document.
Payment has been
received. To the satisfaction of the client, it has been.
And second document is my lord the principal amount that has been.
That was paid earlier.
Yes.
That was paid. Both payments are admitted by the client. I apologize, I could not apprise yesterday because I was not informed by the.
So 48,000 and odd is the amount of interest.
Because it was reduced to 6% and also from the date of order, my lord.
Yes, yes, very good. On account of
Fraudulent
imperfect title of the
title of
yes,
my lord. Auction.
Bank of Baroda
Bank of
Madhumgram.
Baroda. Yes, my lord. Bank of Baroda. They,
Yes, yes.
yes, my lord.
Lekun
Your Lordship, in this matter,
You are appealing.
no, Your Lordship, I've been instructed by the advocate on record in this matter to pray for a Passover. Your Lordship is arguing before another bench of this Honorable High Court. So
Sir, somebody is mentioning, I cannot hear.
I'd be really obliged.
Take microphone, sir. What do you want? You want Passover or
Yes,
time?
yes, Passover.
Very good. Item number 5, Passover.
Highly ob-
I cannot say what I am. File our activity reply item number 7.
6, 7, 8, 9 all are identical matter. This matter relating to my lord. First SRST non-teaching 2010 Group D examination. What happened, my lord, in this?
You are for the?
I am for the petitioner, my lord. In item number 8. 6, 7, 8 and 9 all are identical matter. My lord. And the in the
6, 7,
8,
all
9.
are tagged.
Yes, my lord. 6, 7, 8, 9.
All are identical matter.
Yes, identical and it is tagged in.
subsequently all the matters have been assigned to minor, increment is expiring on 31st of this
31st of
January.
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 And all the matter is tagged in pursuance of the coordinate bench order on 29th October 2024, my lord. In Basudev Bench matter, item number 8. Kindly give that file. On 29th,
So let us
29.
just a minute, sir.
Yes, my lord, kindly
It is
take.
appearing in item number 6.
No.
Six, Lordship, the, আপনি জানাচ্ছেন।
Item number 6 is 24781. 24781 on the last occasion, Mr. Dibyendu Chatterjee appeared on behalf with Mr. Pritam Majumdar and Moinak Singhaparma. He is not appearing.
Yes. Lordship, 6, Lordship, we are for the Madrasa Service Commission respondent.
My lord, kindly
Now, Lordship, the so far 6 is concerned, 6 and Abdul Latif Kota. 6, 7. Lordship, so far the 6, 7 is concerned, Lordship, we have filed our opposition.
Well, our reply in item 7.
In item number 7, you have filed your opposition.
Yes. Now, Lordship, the
And,
6,
and on the last occasion, it has been submitted that you will not file any separate opinion opposition in item number 6.
6. So 6 and 7 we have covered in the affidavit opposition. So first, item number 7,
Hey, ওটা দাও গো।
8 is concerned.
One by one.
file koro, file koro.
And you have stated that the affidavit in opposition of item number 6 be treated as an opposition of item number 6.
6. So 6, Lordship, we are not going to file any Lordship, the opposition because it will cover the same. Issue is the same.
এটা একটু লিখে রাখুন তো ভাই। WPA এটা পুরোটা লিখে রাখবেন। কে আছে?
English দেখবে?
Why has not come? The other exchange of evidence so far as 6 and 7 is complete. And 6?
6, no reply has been filed.
No. In 6 you have not filed any affidavit of opposition.
The issue is 6 and 7 almost all 4 petitions is identical. So far I choose not to file in opposition.
So that will be treated as an opposition.
Cover the 6.
But very good, they do not file.
In my item, my lord,
So we can proceed with this. 6 and 7?
6 and 7. So 6 and 7, Lordships is ready for hearing, but there are some applications addition of party.
You understand that the opposition used by commission in one of the matters.
You are appearing in 7 with you?
Yes, sir.
Yes. Very good.
Now, Lordships, so far this is 6 and 7. 8 and 9 is concerned. So we have decided.
So let us concentrate on 6 and 7. Please tell me what are the interlocutory application in 6 and 7? Ekটু বসুন। Those are to be disposed of first.
Yes, interlocutory application, Lordship, there is addition.
Can 1 and can 3.
One can.
এটা বার করো তো।
Can 1 আছে।
Can 3 দুটো can 3 হবে দেখো।
না, can 3 1, can 2.
Can 1 of 2024 and can 3 of 2024. দুটোতে আলাদা আলাদা আছে দেখো।
Can 1 কি আছে?
Can 1 and can 2 আমি সেখানে দেখতে can 1 and can 3 আছে। দেখি দিন।
না এটা তো এক্সটেনশন।
এটা কোনটা বাবা?
Can 1 টা কি?
না এটা তো দুটোতে আছে, একটা হচ্ছে 24781 আর একটা হচ্ছে 25438। এটা তো আইটেম নাম্বার 7।
Also, can 1 I cannot say. Also, this is not no copy has been served. Also, can 3 is concerned. The learned advocate Farah Gaffar.
Can 2. Can 2 in item number 7.
No, can 2 is the extension of issue.
Dispose of policy.
তো হয়ে গেছে কি?
Can 3 has been disposed of?
Can 2.
Can 3 I am for the additional part.
Can 2 is an application for extension of the order.
Can 3 also we are opposing this.
Can 3 is at the instance of?
Lots of some
Application for addition of part.
By whom?
By the lots of the candidates who perhaps participated in the selection. Data against opposition.
So paragraph 24 is the main contention. Who is for the petitioner? Who is for the addition of party? So come this side. You have not filed any opinion opposition against this application.
This is the it has not lots of the taken into consideration. This can.
So it can be disposed of.
No, we have opposed. Because this is the.
I'll consider your opposition and dispose of the application.
Then we have to file opposition. No, lots of this cannot be because they are.
my lord, may I?
After getting the knowledge that some order has been passed and lots of them by way of a
This is a lingering process.
This is the law. By way of adding a respondent.
Selection process has to be concluded. Everybody who is in the zone of consideration has to be considered.
Absolutely.
So not whether they come with an application for additional party or not, but things have to be disposed of by
Ultimately they have to prove their rights.
No, let them come with the writ petition.
in the event of
That will amount to tantamount to the multiples of suits and proceedings.
No, so then it is not permissible under the law.
but she can-
No, so a respondent cannot get a benefit.
So let me dispose of the. I record your objection. I shall dispose of the application. Take down.
Also, kindly record that I want to file now.
No, if you want to file an objection, I have to give you an opportunity to file a petition.
Then also kindly give me opportunity. I
Very
filed 2 pages.
আচ্ছা লিখে তাহলে ওটা কি লিখলাম ভাই?
Subject to petition or objection at the final stage.
আচ্ছা ওটা লিখলাম তো। এটা একটা কাজ করুন তো ভাই। ওইটা ওই ওপরে প্রথমে কনস্ট্রাক্টটা লিখলেন তো পুরোটা নিয়ে না আবার লিখুন তো WPA 25438 of 2024 এবার লিখুন No, no, have you got any knowledge? তুমি দেখো তো ওখানে ক্যান কটা আছে, ক্যান 1,
In list, there is
ক্যান
no
1
such.
3 কটা আছে দেখো তো।
Immediately, there is no can loss because immediately
No. They just see after item number 7, there are 2 lines of 2 cans. That is why I'm confused.
Yes, can one, can one.
It is in 2 line. একবার তুমি দাও আমাকে দাও, আমি একবার দেখে নিই।
can আছে।
এটা ক্যান 3 হচ্ছে 254388, ঠিক আছে, এটা হচ্ছে 254388।
নাও থাকতে পারে। হ্যাঁ, না এখান থেকে বোঝা যাবে অনলাইন স্ট্যাটাস কানেক্টেড ম্যাটার থাকে।
ক্যান 2 ক্যান 3
কত পাচ্ছেন প্লেস কম।
There is no can in item number 6, তাহলে এটাকে দুবার লেখাবে না, এটাকে একটা জায়গায় লেখাবে, দুবার লেখানো মানে কনফিউজ। এবারে এইটা লিখুন তো ভাই, আইটেম নাম্বার 6 WP এইট নাইন।
Well, kindly take the order dated 29th October 2024. এই চারটে ম্যাটারই মানে got it মানে the order, may I place the order?
Which order, sir?
29th October 2024.
In Basudev Bej and
Vasudev Bej and others, WPA number 26237 of 2024.
Just a minute. You have filed your opinion opposition?
So
My lord,
this,
before that, my lord, I have some submission.
Just a minute. Have you filed
these two
opinion?
matters, Lordship, some issue are different, added issues. So Lordship, these two matters I'm praying for 2 weeks time to file up.
Sir, why it has been tagged together?
But coordinate bench order, my lord.
Initially, WPA 26090, this is not joint for Shodda.
Yes.
That matter apparently was moved on 14th of December 2024. And it was directed to be tagged with Mr. Shami's matter.
এই দেখি বাবু ওটা দাও তো।
Malad, kindly first take
এই
the
তাহলে-
29th of
Yes, I want
October
to
order.
see the tagging order. তুমি আইটেম নাম্বার 9 এর ফাইলটা দাও। এখানেই আছে?
Order dated 22nd.
29th,
Joint to sort the.
13th December.
First in WPA 6090 of 2024.
Yes, there is an order of tagging by me.
Right. Now,
Very good.
paragraph in terms of the liberty granted by your lordship's court, that they have not used an affidavit insofar as item number 9 is concerned, in which I am appearing. In item number 8, my learned friend,
He has also not filed affidavit.
No, not
Yes.
filed, my lord. Today morning, my lord, he handed over a copy that to Abdul Latif matter, item number 7 affidavit in opposition. My learned friend most probably wants to use it. If my learned friend wants to use that affidavit, then it is okay for me. But it is okay.
Just one, there is a small difference between the two matters. Here, in item number 6 and 7 people did not reach a particular stage of the selection as against the persons like his clients and my clients who have completed the interview process and are awaiting publication of results. Subject to correction.
No.
And insofar as
Yes,
item number 9, this is the position.
9 lordship allegation, there,
Be there as it may. So far 8 and 9, what do you want to do?
lordship, I want to file an opposition.
Separate
Some
or-
Slight facts are different. Apart from lordship.
Separate or
7,
separate or one?
issue is same, lordship is subsequent.
Sir, choice is yours.
Yes, I want to file opposition.
No, separately, not here.
Separately.
That I want.
8 and 9 separately.
In my respect.
8 and 9 separately, I want.
Each act of the other matter. It has to be heard separately because here the writ petition to your lordship are persons who have sealed, their fate already, not in so far as participation is concerned.
But in your presence, it has been submitted that it has an identical. Your name is appearing. Then on the last occasion, you have said pray for tagging, and here today you are saying the tagging.
Let it be.
My lord,
এদিকে এসো এসো এদিকে এসো
My lord, kindly take-
এইটাতে না 26090 অর্ডার করবে এটা দুটো একসাথে লিখবে অর্ডারটা হবে 26090 মানে আইটেম
My lord, regarding item number 8, I have separate submission. Because of that, my lord, kindly take 29th October 2024 order first.
29th of.
Yes, my lord.
Yes.
May I read, my lord? Affidavit of service filed on behalf of the petitioner is taken on record. On a similar prayer as in the present writ petition, an order has been passed by a coordinate bench of this court on such and such date in WPA number.
Yes, there is an order of tagging.
Yes, my lord. So there is a order of tagging, my lord, and not only that, my lord, that order is also applicable for my writ petition. Because of that, in item number 7, there is a stay order, my lord. If this, my lord, that order is abide by this writ petition also, then if my lord wants to detag it, my lord, then my lord, in separate stay order ought to, my lord, pass in my writ petition also. Otherwise, my lord, I will suffer. Otherwise, I will suffer, my lord.
No, lordship, this
No,
is.
same order was.
Otherwise, tag, if the coordinate bench tag, when my learned friend was present, there is a tagging order, that's why, my lord, a similar prayer. Otherwise, I will suffer, my lord.
Take down. I got your points.
Previous order.
Listen to my order. এটা তুমি এটাতে লিখবে এইটা আইটেম নাম্বার 9 এটা জমবে ঠিক আছে
Lordship, the issue is identical, but this does
Wait.
not mean that interim order passed in earlier.
learned advocate appearing on behalf of the
Obviously.
learned advocate appearing on behalf of the Madrasa Service Commission prays for extension of time to file affidavit in opposition in both the matters, that is in WPA 26237 of 2024 and in WPA 260 of 90, WPA 26090 of 2024. Stop. He further submits that he intends to file 2 separate affidavit in oppositions in both the writ petitions. Stop. Prayer for extension of time is granted. Madrasa Service Commission is directed to file affidavit in opposition within 2 weeks hence, after serving copies of the same to the learned advocate for the writ petitioners separately. Stop. Affidavits in reply, if there be any, is to be filed within 1 week thereafter. Let the matter be listed under the under the heading hearing.
No, Lordship, let this four matters.
Let the
Four matters appear.
আচ্ছা ভেরি গুড কেটে দাও ওইটা লিখো না ওটা আপাতত কিছু না in the instant matter the instant two matters would be listed along with WPA 24781 of 2024 and WPA 25438 of 2024 as and when the business of this court permits or disposal of the interim applications in connection with the aforementioned two writ petitions, whichever is earlier.
Lordship, this earlier matters directed to be appear on 6th.
So that matter also.
Let the matter also 6th.
2 weeks 1 weeks করেছি তো তাহলে 2 weeks হলে 2 আর 1 then I have to shift that.
Yes.
Otherwise, it will.
তাহলে একটা কাজ করো তো ওই 6 থেকে 13 করে দাও
Otherwise, it will be
আগে
piecemeal
6 থেকে
argument.
13 করে
You are not intending to use any affidavit.
হলো তাহলে তাহলে ওই লাস্ট দুটো ওয়ার্ড কেটে দাও let the matter be let this ওটা করে তাহলে ওইটা কেটে দাও না 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 এইটাই জাস্ট
Order this.
কি একটু উপর থেকে পড়ো না along with WPA যেটা বললাম ওইটা বলেছি না 781 of 2024 and 25438 on February 13 2025
February 30.
So the interim order granted in the other matter may also be related to the
My lord, otherwise, my lord,
This can.
because of that, otherwise, my lord, we will suffer.
Lordship has
My lord, if they somehow if they manage that writ petitioner, we will suffer. Yes.
No, Lordship has
Otherwise,
applied
we will
my
suffer.
studying that material.
at this
Any, item number 8. There. Extremely good.
Call the next man.
Item number 10, my lord, I am appearing for the
এটা fix for hearing কেন? এটা কি ব্যাপার? Oh, I see.
Lordship, on the last occasion, state did not appear.
My
Very
lord,
good.
I am extremely sorry, my lord.
We were asked to give a
Last occasion I did
notice.
not appear, my lord. My lord, I am led by Mr. Lolit Mohan Mahato. My lord,
This is
I have made contact with the concerned
regarding the
district magistrate, my
compassionate
lord, for
appointment.
instruction, my lord. My lord, yesterday I have talked with the district magistrate of Howrah to supply me the instruction, my lord. They have told, my lord, Tuesday or Wednesday instruction will be supplied to me, my lord. Kindly fixed it on any day after Tuesday, my lord.
Lordship, may kindly see the order sheet. Even a day prior to the last date, the similar prayer was made that they are awaiting instructions.
Which memo is sought to be quashed?
My lord,
There is no memo.
Page 46.
No, you know, prayer.
Yes, page 46.
That is the last one where they again asked for inquiry. 5 inquiries have been held. All inquiries have
My lord,
recommended
there was
my
a direction
appointment.
by the commissioner upon the district magistrate, my lord, to, my lord, constitute a 3-man committee, my lord. Sorry.
So the registered reprison can be disposed of
Yes,
by
my lord, by
directing the
directing
committee to
to
dispose,
take a final
to come to a
decision.
finding within a
Lordship, kindly
certain
comes to
period.
page 38. Already it is done.
It's recommended.
Already. Then they again formed a committee. This is the third or fourth committee.
So, according to you, why they have made a departure from this recommendation?
No reason. No reason.
Take down. Don't seek an adjournment.
Yes, ma'am.
I shall proceed with the writ petition otherwise. Call the next matter.
I'm obliged.
Tag matter আছে?
Yes, Lordship, I'm for the petitioner, Lordship.
ও তাহলে ওটাকে তো নিয়ে এসে শুনতে হবে। You are appearing on the petitioner?
Yes, Lordship.
There is an order of tagging with
Yes,
another.
Lordship.
Supply the number. What number is there?
I have something to submit, my lord,
Yes, sir.
for my lord's consideration. But the other tag matter, I am for the petitioner, and the instant matter, I am for the respondents. Both the matters were tagged. And in fact, my lord, from the order sheet, my lord will find that the hearing was practically concluded. There was a direction for filing. My lord-
Concluded before me.
No, no.
Oh,
Before
say like
another
that.
charge, another charge. Your lordship, kindly bear with. And in fact, my lord, by an order dated April 20 or 26, my lord, will find there was a direction for filing written notes on submission. On 17th of May, my lord, I filed. Thereafter, my lord, again, the present writ petitioner in this matter, which is appearing, he didn't file. Then again on my lord, on 20
What has not been filed, sir?
written notes on argument. And there are abruptly, my lord, the matter has gone out of the list of my lord Justice Bharatdar, who was hearing the matter. At this stage, it is there. My written notes on
So exchange of evidence are complete.
everything there. My written notes.
তাহলে
is
একটা
there.
আটা দাও আমি অর্ডার করে দিই।
Written note is there. My lord will find. It has been recorded on 17th of May. I have filed my written notes on submission. That order has not gone to
একটু
further.
আসুন ভাই।
If my lord,
Come back on 22nd.
yes.
Actually, item number 5 was passed over.
Yes.
This is a contempt application appearing for the first time, my lord.
দাও ফাইলটা দাও
Lordship will find your lordship's order at page
page 15
Page
Central
15, my
Bank of
lord.
India.
Page 15. Find the bottom of the page. This was the punishment initially imposed. Reduction of basic pay by 2 stages in the time scale of pay for the period up to superannuation, that is 31st May 2015. With further
Have they
direction,
preferred any appeal?
they have preferred an appeal in the year 2023 itself, but did not get the matter listed. They did not get the matter listed.
There is an order for reinstatement.
No, he has retired from service. Your lordship-
Recalculate the residual.
Yes, yes, and
So it is a
recalculation.
question of disbursement.
Yes, recalculation of the retirement benefits. Since the initial punishment was reduction of basic pay by two stages, your lordship directed reduction of basic pay by 1 stage. So the differential amount needs to be calculated and
I
disbursed.
understood.
He has already superannuated. He is appearing for the first time.
What's your good name, sir?
Pratik Majumdar.
Oh, you were not there in the writ petition.
No.
Also. And what's the name?
Yes, is there.
He is the advocate.
He
of
is the
the-
advocate.
Mr. Mujumdar.
My lord, regarding the item number 12. My lord, item number 12, Mr. Arnav Chakraborty is referring, I am praying for accommodation, lordship.
My lord, kindly twist the this mistake.
You should make it not today. 11টা হয়ে গেছে না 11 12 not today করে নাও
My lord, kindly twist the
fix I cannot fix it now. If you have got any difficulty seek an accommodation through any of your junior or friend.
To mention one matter, Section 20 of the academic side. On behalf of Mr. Anima Chakor, probably yesterday from this court will be referring. He informed me through a telephone that doctor advised him not to go for at least 2 weeks. That is why
Item number
20.
you are for the
I am mentioning on behalf of Anima Chakor for the petition.
petitioner.
Yesterday, my lord, he came here, this court, he came in.
Is it not be possible at the time of to mention at the time of call?
Yes, marked it. I have got another.
একটু না এই কল্যাণ
Actually,
কল্যাণ করে আসো আইটেম নাম্বার 20 টা একটু
Well, there are two matters assigned to your lordship, my lord.
yes
One is, my lord, the civil division case, another is writ.
civil revision case and the rate
And
civil
the
revision is at the instance of
At the instance of Kolkata Municipal Corporation. And the
against
writ
the
petition
challenging the order.
challenging the order of the assessment tribunal.
Very good.
And second, well, the writ petition is on the part of the opposite party. Opposite party petitioner is he wants the execution of the order of the learned tribunal. Therefore, the court, my lord,
Execution of the learned tribunal.
the order
Execution
which,
of the order of the learned tribunal.
order which is under challenge in the civil division case, he wants that order to be executed.
Is
Therefore,
an
the
order,
court
it is an order of assessment of tax.
assessment.
Yes, sir. Yes.
Therefore, the court,
So
my
how
lord,
the order is to be executed?
My lord, we
Because, my
have
lord-
filed, my lord, the writ application initially, my lord, because the order of assessment was basically fixed, rather modified by the tribunal, and my lord, that was not implemented. Because
That is what implemented.
yes. So for that, we came up before this honorable court in the writ application. Now, my lord, when this was filed, thereafter, my lord, my learned friend entered appearance and sought the leave of the court to file a civil revision. And subsequent to that, my lord, the civil revision was filed. So once the civil revision was filed, the writ automatically went out of the list because it fell from his lordship, as his lordship then was. My lord, taking the determination that let the civil revision application be heard out and disposed of, based on
Very
which we will be
very
hearing. Now, my lord, since civil revision is the first one which has to be done, because if that order is there, if your lordship feels that this order should not be interfered with, well, then in that even automatically
Writ petition will,
I get my remedy under the
very
writ. And if not,
Hey, what is the writ petition? What is the writ petition? Hey, what is the civil revision?
so my lord, my friend will be starting, I will be asking.
Yes, yes, sure. Oh, it was with my determination.
Originally, my lord, it was
and your lordship, in fact, my lord, sometimes your lordship hard also.
lordship will recollect, I know that. So
Oh.
it was last year lordship had heard it, perhaps sitting in court number 22, perhaps.
Thereafter, on account of change of determination, it goes.
So, my lord, the matter went out.
Then it came, appeared in a different bench.
That's
And
right.
then it came,
Revision application did not appear. The writ appeared. And then we pressed before the court that unless and until the revision.
No, it did not appear before any other bench.
No, it did not appear.
My order, last order is 15/5/2020.
So, my lord, we thought it is better to get it assigned before your lordship. So we made a joint press.
Very fair. Very nice.
Much obliged.
Yes.
may the,
Yes, Mr. Bose.
well, the order under challenge
Hmm.
is dated, my lord, 8th of November 2017.
Yes.
This is the challenge of the valuation has been substantially reduced. The valuation was made, my lord, with effect from 4th quarter of 2010-11. The amount has been mentioned, and my lord, that
he say land, vacant land was purchased by the petitioner, opposite party rather, opposite party purchased the plot of land by 2 lease deeds.
By two?
Lease deeds.
How by
Lease deed, but not purchase, lease obtained, my lord.
I see.
Lease obtained, my lord, from West Bengal Industry Development Corporation.
Very nice.
And my lord, the is a 21 Pottery Road. And my lord, the first one of the lease obtained on 14 December 2007. There the area of the land was 6.93 kathas. And second lease was taken, my lord, 4th March 2009.
Where will get that?
And in the list of days, and also it is also a petition or the order itself. Logically, see, the decision which exists page 2 of the writ petition. I'm sorry, my lord, the order of the learned tribunal.
Page 2.
And the list of days I have mentioned. It appears from the IP that the premises in question 20 on Pottery Road, Kolkata 15, ward number 56 is vacant land measuring 9.38 kathas, corresponding to total my lord, 9.38 katha, my lord, in 2 lease deeds. One lease deed contains my lord 6.93 kathas and second one my lord 2.45 kathas. Total square foot my lord 6754
Yes.
square foot.
Hmm.
It further appears that IP that the proposal was made by the correspondent taking the land value 6,42,389 and the total value of land in question was calculated such and such. LOC has got it, my lord, the total amount.
Hmm.
60,25,609.
Hmm.
Taking the total value vacant land in question, the assessment annual valuation was proposed by the department at the rate of 7% of the total value. That is, my lord, 42 lakhs 1,790. 4 lakhs 21,790. Then, my lord, it is heard by the parties. They refer to one, my lord, the judgment MMA 2851 of 2009, 2009 in respect of 21 Pottery Road, 50 ward number 56, same properties in respect of a new 5-story building. The difference is, my lord, is a part of the total the industrial development area, land of the West Bengal Industry Development, my lord, granted the lease for different persons, plot by plot. Well, so far as his land is concerned, opposite party's land is concerned, they purchase, my lord, the vacant land.
Yes.
Total 9.38. And the another plot, my lord, there is a 5-story, new 5-story building, where the learned tribunal fixed the RR at the rate of rupees 1.65 per square feet with effect from 3rd quarter 2008-9. Then it is said the learned appellant further stated that the IB is silent regarding the basis of proposal made by the respondent fixing the value of the land per kata and also the reasons for calculation AV at the 7% of the total value of land on the basis of the valuation per kata. It is further argued that that as per section 174(4)(a) has no manner of application in the instant case. Well, I am just posing here for a moment that it was specifically stated that the market value of the land, 7% of the market value of the land was considered to determine the annual valuation. Now the question is whether this method is applicable under the law. So far as the vacant land is question. Your Lordship had the occasion to see in different cases that 174 is the section provision which provides for the modalities to determine the annual valuation. Rent is the method.
Hey, Kolkata Municipal Corporation Act is here with me. 174 subsection 4.
No, 174, on Learned Tribunal says, well, 174 4A has no manner of application in this instant case. Well, we have also not relied on that particular provision.
Very good.
But we relied on a different provision to assess the annual valuation of the vacant land of the total quantum of land on total quantum land. The Learned Tribunal has recorded a particular provision which is incorrectly noted the section itself, the section, my lord, because this section 170, next paragraph, you will see, my lord, it is argued that the learned for the respondent that the other order of the hearing officer assessment new building is reasonable and should be affirmed. Learned advocate for the respondent went on saying that the judgment relates to building which was leased out and
Respondent means the Kolkata Municipal Corporation.
My lord?
Respondent is the Kolkata Municipal Corporation before the tribunal.
Yes.
Yes.
The referred case is not comparable in the instant case, which is the vacant land. It is further argued that the land advocate for the respondent that the assessment was done 174(3). This is wrong quotation of the particular section. Wrong quotation, I mean the number. Section actually 7% relates to the section 174(2). Unamended section.
Unamended.
Unamended.
The annual valuation of any land which is not built upon shall be fixed at 7% of the estimated market value of the land.
That is the issue here. So far as my client is concerned, the total market value of the land, my lord, I have got it from the IGR report, my lord, what is the value of the property. And then the 7% calculation to be made, since it is a land which was not built upon.
So what is the contention of the
The
appellant?
contention of the Learned Tribunal has taken to consideration. The next page you will see the 174(3) has been quoted, but that is not related section at all. If you lordship read the section itself, you will find it has no connection with that particular the assessment and the
gross annual rent of any class or classes of land or buildings used exclusively for hospital education.
No, it is not an issue.
No.
He said wrongly quoted that not quotation is wrong and the placement of the 7% is wrong because IB itself says 7% of the market value of the land.
No, the contention of the appellant before the tribunal was that the IB is silent regarding the basis of the proposal for fixing the value of land cutter, which according to you got from the IGR. That is
IGR, I am sure. Yes, I showed to Lordship that
also the reason of calculation of AB at 7%. It is argued by the order of the hearing of is reasonable. Advocate for the actor saying that the judgment relates to a building was leased out and referred to is not comparable. So it has been wrongly good. Very good. So what is the finding?
But finding the you come to
it's a hospital.
Next paragraph. Next paragraph, Learned Advocate for the appellant has relied on the Municipal Commission Circular number 35 2010-11 dated 5th October 2010. In the said circular, the resolution of the Mayor in Council has been relied on. Resolution 2 is allowed is as follows: assessment of building with land appertaining thereto, section 174(1) to be read with section 178(2)(I). If any residential or non-residential premises includes the land as well as construction, then the appertaining land excludes the area equivalent of the covered area at the ground level of the construction will be treated as vacant land as per notarized such and such for the purpose of assessment of property tax. Learned Tribunal is completely wrong in referring to the circular and relied on, because in a case where the building has been constructed on a particular land, the appertaining land within the premises that may be considered as a vacant land for the purpose of assessment.
If any residential or non-residential premises includes lands as well as construction, then the appertaining land excluding the area equivalent to at the rate will be treated as yes.
In that case, where a land built upon, but there are certain vacant land.
Suppose a measurement of the land is 1000 square feet.
Yes.
And the built up area is 700 square feet.
Yeah.
So 700 square feet is to be considered as a covered area and 300 pesos to be
Vacant land.
vacant.
That may be considered in a particular mode. That is the circular.
The place of the relevant quarter of the left out of the land. Yes, sir.
But that is in a different case. But that is not the case here.
So according to you, this circulars has got no application.
Has
here.
no application at all because it's a completely vacant land admittedly.
Yes.
And the vacant land to be decided provided under section 174(2). Question is 174(2) calculation has been properly made or not. This is my
absolutely.
This is a precise point. If your lordship now kindly come to on such basis, learned tribunal proceeded. The land on building, my lord, whatever in Pottery Road is a particular premise, a particular plot of land of that premises. Land with building is a different mode, my lord, it was applied. 174(1) was applied. And that can be the basis for determination of the land under section 174(2). The learned tribunal took into concern, that is the reason why it was said it's not comparable.
And it is the argument of the learned advocate for the appellant that the building in question and the land in question, vacant land in question, and the referred case, which is the building which is covered under the referred case comes under the purview of the resolution. So what is the finding then?
Then finding then that the learned tribunal took into consideration that on that basis they took into consideration the RR of the vacant land will be 50% of the RR of the newly constructed building.
Where I will get it there?
Well, illogically after page 5, after second, third paragraph, fourth paragraph, the RR of the vacant land will be 50% of the RR of the newly constructed building of the referred case. The referred case means, my lord, the land with building. That is a different mode applied under 174(1). Then says, having heard the submission of both sides in the light of the documents referred cases.
The RR stands for?
Reasonable rent.
Reasonable rent. And basis submission, and I find basis on the it is admitted the vacant land of the present case and the building of the referred case which is the same premises.
And then say 174(3) of it would be 172, determining the assessment of the vacant land of the present premise case cannot be accepted. Then he went on calculating the amount at the rate of 50 paisa per square feet per month of the total area of the area.
Have you got any photocopy of the page number 5 because the side has been torn out?
Wait a minute. Wait one.
Oh, I see.
My lord.
Since the property in question, which is the subject matter of the instant litigation, and since the property of the referred case situates in the same premises.
Premises in a different plot.
No, in the same premises number, which is why the tribunal applied that premises. I see.
That is the reason, my lord, he took into that. Well, our submission would be, my lord, that section 174(1) in a case where the land with building to be, my lord, the assessment, and application of that particular circular is applicable in that case. But so far as the vacant land is question, since because it is the land of the West Bengal Industrial Development Corporation. Now you logically see, my lord, that the valuation of the property, that what we have obtained,
Wherefrom we'll get that it is a separate plot.
my lord,
Wherefrom we'll get that it is a
identified plot. There's a different areas are mentioned in the lease deed. Lease deed is a different areas. Because
Well,
the 9.38 katas and 2.6
that has been annexed with the instant revisional application.
lease deed to the
Lease deeds, my lord, we have annexed in our opposition.
opposition.
Oh, opposition has been used in the petition, in the revisional application.
Yes, my lord, affidavit in opposition, which we have filed, my lord, we have annexed the lease deeds.
How many lease deeds are there?
Two, my lord, two lease deeds are there. My lord, should I give the pages?
Page 29.
It starts from, my lord, one is at page 29 and the other, my lord, is at page 14.
Not, yes, that I'm on. Page 13, 14, one is 13, no?
Yes, my lord, that is one of the lease. The other one is at page 20. Because there are two.
Another is that?
Page 29. These are all empty land. Vacant land, no building is there.
ঠিক আছে, ওটা খুলে তাতে হবে। It's identified, the plot by plot is as
Plot
mentioned.
number 7 and plot number 15.
And the bounded by, that is also been mentioned. আরেকটা ছিল, দুটো দিলেন, এটা 2.45. আরেকটা আছে। এই পাতা উঠেছে, কি জন্য পাতা উঠেছে? এমনি দেখে পড়ো নাহলে পাতা বন্ধ করো।
So far as the lease deed of at page number 29 is concerned, it is with regard to a premises or is a vacant land. All premises now at a India
All are vacant land.
Has
But admitted to
Kathas and
legislation,
are being part of
the order of-
municipal
Vacant
area.
land.
Page 40.
All are vacant.
The plot number very
ধরো।
There was a huge plot, my lord, at the Tangra.
It's a vacant land. There is no dispute about that. It is the order.
I got that.
In the order itself is that insane. Now the question, my lord, that evaluationally sees you inquired of the valuation of the property, that the information we have received logically come to my page. পাতার নাম্বারটা আমার কিছু দেয়নি। আপনার পেজ 16 লজিক্যালি একটা পাতার নাম্বার জানে কিভাবে লিখবেন? কোথায় তোমার পাতার নাম? তোমার লিখলেন? We must ask for this is the letter Joint Secretary Finance Department, Inspector General of Registration and Commissioner of Stamp Revenue, West Bengal. Well, he supplied the information about the market value of the land of different of the
6,42,389.
yes, LOC has got my lord. Pottery Road, my lord, LOC has
Marking is my marking is there. Yes,
642
389.
642,389. This is the market value.
So naturally we have applied 7%.
This is the per kata.
That is applying the
174.2.
unamended provision of 174 within bracket 2.
2. Well, this is the per kata. But I find, my lord, one thing after that, but this is the basis for determination of annual valuation by the Kolkata Municipal Corporation.
Yes.
But the learned tribunal erroneously approached the issue on a different context, which in my submission, first of all, 174(3) has no application. He also recorded that. And then he said that the particular circular, first of all, even if the circular is there, the circular cannot override the statutory provision. Statutory provision is there, and that particular circular is also applicable in a different context, because where the land and building, the appertaining land to be taken into consideration on that basis. That cannot be applied so far as the case was the vacant land in question. Now it is to be decided by your lordship, my lord, whether the proposal as made by us is correct or the learned tribunal or the basis which has been mentioned is correct. Well, my response submission would be that having regard to that particular section, my lord.
I understand your contention.
And another, my lord, I submit, my lord, that possibly in the amount of calculation, the total annual valuation, it could have been much. My learned friend could have, my lord, taken the wrong, my lord, committed by the authorities. Illogically sees, my lord, that total the valuation 6 lakhs 42,389. This is the land, but the amount, the per kata. Total land area, my lord.
9.38 kata.
9.38. Then calculation has been made, my lord.
By multiplication.
Multiplication
Therefore,
60.
that 7% has been added.
6025609. If your lordship takes into account 7% of this, my lord, the calculation, then whatever has been written here, that is, my lord, one digit is missing. It would be much more. Corona, 7%. 6025 609. 6025 609. 6025 609. Oh, that bullying.
No, it's same. 421792.
That comes to 42179. Oh, then it's already. But I possibly made a mistake. What will be 421,792? Yes, madam. Right, madam. I'm sorry, madam. Then it says 4,21,790. Now it has been reduced to. It has been reduced to illogical, my lord.
So far as arithmetical calculation is correct.
My lord, the illogical exceeds, my lord. Then upon taking into account 50 paisa per square feet, the learned tribunal.
No, I understand. I am to decide whether the tribunal is at all justified in applying the provision of 174 subsection 3 read with the circular. That is true. Yes, madam.
Another aspect my learned has taken, of course, you will be submitting regarding the delay in presenting the civil division application. I have explained in particular paragraph, my lord, 8 to 9, total explanation is there. And he has also referred to section 189(10)(a), which provides for the review. Your lordship, sitting in another court, my lord, in similar type of cases, your lordship has that power of review cannot curtail the jurisdiction of the High Court under Article 227. That was also, my lord, delivered in the assessment tribunal case, and also accepted the reasonings, the delay part, so far as the civil division is question.
Very good.
My lord.
Yes, madam.
Will you permit to take back the? Since
No. It's required.
my lord, since my learned friend has stopped with the delay, my lord, let me start from there and go back. Now, my lord, if your lordship kindly sees, my lord, the order which has been placed before your lordship of 8th November 2017, which was passed by the Municipal Assessment Tribunal, my lord, that was dated 8th of November 2017. Now, my lord, 189.10A, as your lordship knows, I'm just for my satisfaction, I'm placing it once again. My lord, it is very clear. It says that two subsections are very important, my lord. That is 189.9 and 189.10A. Now, 189.9 is basically something which actually debars exercise of civil jurisdiction in cases of dispute, which your lordship is well aware of. But just I'm reading it out for my own satisfaction. Now, my lord, 189.9, if your lordship can kindly take it.
I have.
189.9.
Hmm.
My lord, may I place, my lord? The decision of the tribunal with regard to valuation or assessment shall be final, and no suit or proceeding shall lie in any civil court in respect of any matter which has been or may be referred to or has been decided by the tribunal. Then, my lord, comes 10A, because this is more important. The reason why 10A, my lord, was brought in is by way of an amendment. Your lordship shall see it. That is, my lord, was inserted with effect from 1/5/2007. Now, my lord, the reason why it was brought in was very simple. The thing is that, my lord, an order of assessment when passed has to be implemented by issuing of, my lord, the demand for payment of the tax and so on and so forth upon the assessee who has been backed with that order. So naturally, there has to be some time frame within which that particular assessment has to be objected, if at all. So, my lord, 10A, if I go by the word as has been legislated, my lord, the municipal commissioner within 90 days from the date of passing of the order by Municipal Assessment Tribunal, by giving reasons in writing, prefer a petition before the Municipal Assessment Tribunal under this section for review of the order passed by the said Municipal Assessment Tribunal. So this is the reason why, my lord, it was given. So you have a 90 days time. Now, my lord, what my learned friend has done, my lord, they sat over the judgment. They sat over the judgment despite letters being issued. Now, I will come to the factual metrics and I shall show, my lord, how this is something where my friend cannot perhaps take the benefit of the judgments which he is trying to refer to. The reason is, my lord, till the date of filing of the writ petition, where we sought an intervention of the court for getting the thing recorded and to issue the demand for payment, my lord, based on the assessment, my lord, they were sitting over the matter. Now, once that came up before the court, they appeared and they sought for leave to take instruction and come back. Thereafter, my lord, they came back with a plea that we are getting a revisional application ready and we want some time. And thereafter, my lord, they filed it, and accordingly this matter was kept in abeyance. So this is what is the crux of the case. Now, my lord, your lordship is well aware of the fact that under the chapter of this assessment, my lord, when an assessment is done under section 190 of the Municipal Corporation Act, my lord, that is having a binding effect. Now, my lord, let us see what has happened in this case. 2017 an order was passed. It is not that that was not contested. It was very much contested. Both parties were aware of the order. They have not even spelled out at one juncture that this is something which we were unaware of. They were fully aware of. They sat over the issue. They sat over till, my lord, we came up here. So, my lord, this is something perhaps, my lord, is a bar. Now, my lord, let us come to the factual metrics. My lord, if your lordship sees, my lord, this lease which I have shown, which your lordship was actually scrutinizing in details, my lord, these were all executed by West Bengal Industrial Development Corporation Limited. The reason is, my lord, there was huge plot of vacant land which was lying unutilized just for the purpose of facilitating industrial development out here. My lord, these people decided that this should be let out to the intending person who wants to set up industry and for small scale entrepreneurs. Now, that is what was the main idea behind it. Now, if this reference order, my lord, which is, this is also part of that huge plot. In small sectors, my lord, this was let out in these. First we took one, thereafter we took another. so that we can actually utilize it for the purpose of the industrial growth out there. Now, my lord, that is what was the reason for taking the thing in two separate slots by way of two separate leases. Now, my lord, if we go to the backdrop of this case, my lord, when this thing was taken out, my lord, there was, my lord, Sona promoters who were the one who were basically given in lease originally. Now, my lord, the Sona promoters, subsequent to that, my lord, what happened is that I have prepared a list of that I shall just hand over. My lord, they amalgamated and with Alpha Stitch Art Limited.
Ma'am, sorry for the interruption.
Yes.
Are those factual aspects
My
at all
lord,
necessary?
because the
I believe no.
today, my lord, we are Alpha Stage before your lordship.
Very good.
Now, my lord, what is more important here is, now, my lord,
Be
I
that
will
as
take
it
your
may,
lordship
you are possessing a leasehold, two leasehold land
two plots.
over the
21 Pottery Road.
Pottery
That's a common address. Now, this 21 Pottery Road, the judgment which has been referred to while passing the order dated 8th of November 2017, my lord, that particular order was never appealed. Nothing has been done, that has
Right.
been implemented.
Absolutely.
Now, my lord, that is also a plot within this area of 21 Pottery Road. My lord, I have annexed that order. If your lordship kindly turns to my affidavit in opposition.
Page number?
Page number 154. Rather, it starts, my lord, from 156. This was the order which was passed on 25th August 2015. 156, annexure end. Yes, my lord. So, my lord, here, kindly sees premises number is 21 Potteries Road.
Yes.
And to take effect from the third quarter of 2008-2009. The very first page, my lord. Your lordship has got it? The SSC number has to be different. Now, my lord, let us come to the body of the order. That is 157, if I may take your lordship to. My lord, this is an appeal under section 189 of the KMC Act of 1980 against the order dated 7/10/2009 passed by the learned hearing officer fixing NRAV at 145260 with effect from third quarter of 2008-2009 in respect of MPL premises number 21 Potteries Road, Kolkata, such and such under ward number 056.
Ma'am,
yes.
you have to read the previous paragraph. This is just after the paragraph after the decision with reason.
My lord, this is the paragraph 157, page 157 I'm reading. Your lordship is looking at a different page.
No, 157. I'm on.
Immediate after decision with reason.
Yes.
156, my lord.
Oh, it's.
My affidavit, my lord.
Yes.
Your lordship.
No. I'm on 158. I'm sorry.
Yes.
Yes.
So,
Sorry.
my lord, this
Please
is.
proceed.
Yes. So, this is the first paragraph. My lord, the premises number kindly marks. That's 21 Pottery Road, Kolkata.
Yes.
And ward number is specified. Here, my lord, again, like us, he is a lessee in respect of the demised premises, as well as a person liable to pay its municipal taxes. On receipt of a hearing notice, an objection was put before the learned hearing officer KMC against the proposed enhancement of rent in respect of the demised premises, and after hearing, learned hearing officer has been pleased to determine and fix its NRAV at rupees 145,260 with effect from third quarter of 2008-2009, which is not excessive but also unfair, unjust, arbitrary, and not in accordance with the settled principle as laid down as to the applicability of the same rate of rent in respect of nearby premises and vicinity also. Therefore, the AV impugn needs modification, the annual valuation impugn needs modification invoking the powers under section 189(5) of the Kolkata Municipal Corporation Act. Resisting the above, it is argued that the demised premises is a thickly populated area having well connectivity with other parts of the metropolitan city Kolkata, that apart all the KMC amenities such as drainage, sewerage, electricity, roads, water supply, etc. are available there. In such a state, the RR of the demised premises is fixed by the learned HO at ₹2 per square feet per month in conformity with the rate of rent of nearby premises of like nature is quite justified and calls for no interference. Well, this was basically the pleading and objection which was raised on behalf of the municipality. Therefore, the instant appeal is liable to be dismissed with cost. Now, my lord, if your lordship turns to the next page, there is decision with reason. Now, here, my lord, this was an area of 1345 square feet. So let us skip this part.
No, don't skip. Please read the line. It is very relevant.
Admittedly, the demised premises is a 5-storied building having an area of 1345 square feet.
Mr. Ghosh is on that. Whether it is the assessment is made in respect of a 5-storied building, the same formula would apply in case of a vacant land or not.
My lord, here, my lord, the
Because the tribunal, according to Mr. Ghosh, the tribunal has gone into in such a manner that since in 21 Pottery Road, a 5-story building is there, so the remaining portion of the vacant land is to be assessed as a residuary vacant land within the meaning of unamended provision of section 172. 172 subsection 174 subsection 2. No. So far as the building is concerned, that was
Building part is 174, what mal it is applicable.
sorry.
So far as the land with building,
Huh.
then 174(1) is applicable, but so far as the vacant land is specifically mentioned 174(2). Let us see 174(2).
No, you showed that portion, no? So building and remaining portion of the land is to be
Oh,
assessed.
that's circular.
There is a circular.
Circular in the
Whether
judgment itself is mentioned.
that is will apply or not.
Yes.
Mr. Ghosh is on that.
My lord, I'm just taking your lordship to the difference because there is some difference definitely here. My lord, here, my lord, let us come back to the paragraph where it says that admittedly the demised premises is having 5-storied building area, having an area of 1345 square feet in each floor, totaling to 6725 square feet in its entirety used for such and such purpose. Now, my lord, let us come down. These are all, my lord, details with respect to, and my lord, here, my lord, the RR was fixed at 0.84 per square feet per month.
Yes.
Now, my lord, next page, if your lordship turns to, my lord, kindly sees the calculation, considering, my lord, that this is a premises which is having a building to it. My lord, it was done as 6725, that's the square feet, my lord, and into 1.65, my lord, that is the price per square feet of that premises, considering that there is a 5-storied building, into 7 minus 10%, and my lord, that is what they come to. Now, my lord, this is how it went up. Now, my lord, I come back to my order. If your lordship kindly sees, here again, the premises is again 21 Potteries Road. And my lord, here is from 4th quarter of 2010 to 2011. And your lordship has already checked up the calculation, so I need not press it once again. Now, here, my lord, the total area is again 6754 square feet, which your lordship shall find in my affidavit in opposition itself at page 70. The last paragraph, which is immediately after the head decision with reason. So, my lord, here it is again 056. This is also 056. Now, here, my lord, kindly sees that here the area is 9.38 katha and it is an absolute vacant land.
Which one?
Our land, our case.
Yes.
That is page 70. Now, my lord, kindly turns page 70 of my affidavit in opposition. Since I am going with the opposition, my lord, I am just trying to club it in one same brief so that your lordship is otherwise in a position to. Now, my lord, if your lordship kindly turns to page 71 now. That's the internal page 3 of the order.
Yes.
Third paragraph. Now, my lord, here the learned advocate for the appellant has argued that the hearing officer arbitrarily fixed the annual valuation without paying any respect to the provision of the Act of 1980. The learned advocate for the appellant has relied on the copy of the decision in MAA number 2851 of 2009. That is the, my lord, that is what I had just shown your lordship. My lord, here again, kindly sees what we have placed, what the appellant has placed. That is, respect of a 5-storied building wherein the learned tribunal was pleased to fix the RR at a rate of 1.65 per square feet per month. So, my lord, since it was 5-storied building, the argument as was advanced by the learned advocate appearing on behalf of the appellant was to the effect that here the valuation would be 1.65 per square feet per month. So that is how it was done. Now, my lord, kindly sees the learned advocate for the appellant has further argued that the IB, that is, my lord, the assessment book, is silent regarding the basis of the proposal made by the respondent fixing the value of the land per katha at 642. That is, my lord, which has been just demonstrated before your lordship, that the chart where the annual valuation has been and also the reason for calculation of the annual valuation at 7% of the total value of land on the basis of such valuation per kata. It was further argued that section 174 4A has no manner of application in the instant case. On the other hand, it is argued by the learned advocate for the respondent that the order of the hearing officer of assessment of the new building is reasonable and should be affirmed. Learned advocate for the respondent went on saying that the judgment relates to a building which was leased out and referred case is not comparable in the instant case which is vacant. So this is, my lord, what your lordship is really wanting me to address on. It is further argued that the learned advocate for the respondent that the assessment was done under section 174(3). Now, my lord, 174(3) is, my lord,
With
what
regard to
was-
the hospital and educational institution.
Yes. Now, my lord, this is what was submitted by them. Under section 174(3) of the Act states, if the gross annual rent of any class or classes of land or building.
Please keep over, Madam Sanal, that I don't require that.
Yes. So we have already mentioned that the assessment book is silent about the basis of the proposal placed, calculation done, determining the annual value of the land in question and affirmed by the learned HO. The respondent is totally silent about reasoning of the order passed by the HO while confirming the proposal of the respondent's department. Copy of the order of the learned HO, except appearing in the IB, was not relied on, from which the reason of accepting the proposal of the respondent department is justified. The learned advocate for the appellant has relied on Municipal Commissioner Circular, my lord, which was dated 5th of October 2010. Well, I shall take your lordship to the circular. I have also annexed it. In the said circular, a resolution, the resolution mayor in council has been relied. Resolution number 2 is as follows. Assessment of building with land appurtenant thereto. My lord, under section this, if any residential or non-residential premise, including land, and I am skipping this part, will be treated as vacant land. Now, my lord, I will show it from the circular itself. Now, my lord, the basis or the prevailing respective RR in the area, the last part, sentence of that particular paragraph, my lord, is the basis or the prevailing respective RR in that area at the relevant quarter of assessment may be considered as the RR of the building. For appurtenant left out land, the RR per square feet will be taken as 50% of the RR per square feet, so taken for constructed area. So, my lord, that is what it was considered. The learned advocate for the appellant has argued that the premises in question, that is land, and the premises is referred case number such and such, that is the judgment which I has just placed before your lordship, are same, namely 21 Potteries Road, ward number 56. So it is in fact ward number 56 and the premises number is also same. In the referred case, there is a new 5-storied building and the present premises is a vacant land. So, my lord, we have argued that. Accordingly, to the learned advocate for the appellant, the land in question of the present case and the newly constructed building of the referred case will come within the purview of resolution number 2 of the above mentioned circular. So, I'll take your lordship to the circular just within a few more minutes. So, we find the basis in the submission of the learned advocate. So, my lord, it is our case that when in the same premises under the same ward for a 5-storied building, the valuation could be at the rate of 1.5 per square feet. So our rate will be a bit lower than that. So that was what was submitted. Next, my lord, we find the basis in the submission. IT is admitted and it is admitted that the vacant land of the present case and the building of the referred case are situated at 421 Potteries Road and same ward number. So that is the factual part which is again admitted and that is also confirmed by my learned friend. So there is no dispute on that. So the RR of the vacant land of the present case will be determined on the basis of RR of the newly constructed building.
So this is the disputed part. So RR of the vacant land of the present case will be determined on the basis of the RR of the newly constructed building, both situated at same premises, namely 21 Pottery Road, Kolkata 50.
Now, my lord, kindly take
That
the
is
pause.
that is the main point.
My lord, kindly takes a pause because that is something which is basically the start. The following line is basically defining how the mode of calculation was done. My lord, kindly sees the RR of the vacant land will be 50% of the RR of the newly constructed building of the referred. So
it has been done on the basis of the circular.
No, my lord.
The 50% has been done on the basis of the circular.
Another thing, my lord, this RR of 50% of the RR of the newly constructed, so the premises or the case which was taken into reference while passing this order was a particular land or premises which was considering the
Madam,
thing what
sorry
is
for
there.
the interruption.
Yes.
Well, you have to ascertain as to whether your judges understand your argument or not.
Of course, your lordship does.
Your question is, the learned tribunal found that the present case will be RR of the vacant land of the present case will be determined on the basis of the RR of the newly constructed building. Is one finding. First finding. Second finding is, what would be the quantum of the RR? The RR of the vacant land will be the 50% of the RR of the newly constructed building. So, the tribunal has come to a second finding. And both the findings are basically based on this circular, which has been stated in the last paragraph of paragraph number 4.
Yes. Now, my lord, I will just add a simple sentence to this. My lord, this circular was never in challenge. One. Second is, my lord, this order was also never in challenge.
No, Mr. Ghosh has raised the question of applicability of the RR, applicability of the circular in the case in hand. Or in the
my lord,
that is to be
that is why I am trying to take your lordship.
Yes.
Now, my lord, here, if we go by this two particular thing which has been pointed out, that is, my lord, while we are basically going with the RR, the calculation, my lord, what is to be taken into account? The first thing which was taken into consideration is that the case which has already been decided on that same plot and the same wall. So, but the only variation was that amount was, my lord, considering that it is a 5-storied building. And here, my lord, since it was not, the second line comes in. The second line comes in because if it would have been the first thing, then that 1.25 which your lordship has seen in the earlier judgment would have been the equation to the calculation. But they have not done that. What they did instead, my lord, they went in and said that since this is basically a vacant land, so what we will do, my lord, kindly comes down a bit. Thus, the present annual valuation of the premises will be, my lord, so this is how the valuation starts. Before that, my lord, here, if we go to having regard to the submission, my lord, kindly sees of both sides. My lord, here the question should be fixed at 0.50 per square feet per month for the vacant land with effect from fourth quarter of.
That is the 50%. That is
My
the
lord-
50% of the valuation in respect of the covered area. Yes.
Uncovered area. My lord, because it's a vacant land.
Which is why it has been made 50%.
Yes, because it is a vacant land. Now, my lord, what he does further is that it goes ahead and calculates it by considering this rate instead of 0.50, it considers it as 1. As a 1 rupee, my lord, thing. Because if your lordship does that calculation, your lordship will come to this figure of 70.
No, ma'am. So far 6754 is concerned, it comes from the earlier valuation in respect of the covered area. Since your land is vacant.
My lord, kindly see the calculation once again.
Huh.
I'll just take your lordship just to that page. Kindly comes to page 159. 159, read this with 73.
Yes, ma'am.
My lord, this is the premises having 5 stories in the same plot. Here, my lord, it has been taken as 1.65. The lordship has got it.
Yes.
And the area is 6725.
I'm sorry.
into
So
12 is the
1.65.
common, into 12 is the 12-month thing.
So
Minus
it
10%.
is rate per square feet.
Rate per square feet.
So it has been assessed as 50 paisa per square feet.
Here. But instead of doing that, what the tribunal proposed to do is that since we had actually assessed the annual valuation at the rate of 1 rupee, instead of 0.5, we computed it at the rate of 1 rupee. So the tribunal proceeded further. It said, but in the memo of appeal, the appellant has proposed the annual valuation as 73,000, which is higher than the calculated above.
So which we accept.
So what they did is that to ensure that the municipality doesn't suffer, instead of going by that particular circular where it was 0.50, it went for the higher rate which we had offered. And accordingly, my lord, this was fixed. So it is not that it went down. And my lord, what my learned friend is saying is that this is a different thing, because that is with respect to a 5-storied building which is there. That is the plot which was given. So that will have definitely a different valuation than that of an open vacant land. But look, that is the reason why instead of 1.65, the calculation, the equation actually fitted in the quantum of 0.50. But since it was coming down to around 36,000, the tribunals thought it fit that let us go by the offer or the proposal which has been placed in the memorandum.
I understand your case.
So, my lord, that is one of the things which has been done. So, it is not that, my lord, it has gone in for a reduction, it went for the higher one. And, my lord, here, I would show your lordship that particular notification, since now, by now, your lordship is absolutely certain that this is how it was done. That is at page 161, just for your lordship's reference. Now, my lord, after this was passed, they chose to sit over the issue. So, my lord, again, I come back to my initial submission that now whatever they are wanting to say is basically barred because they have also missed out their chance of review. Now, just to fill up the gap, today after this writ was filed, they have chosen to come up in this revisional application. Now, your lordship, in one of the judgment I had read, my lord, your lordship held that, okay, fine. If there is something which is apparent on the face of it, why not? The court can, sitting in this prerogative writ jurisdiction, invoking 227, it can exercise the superintendent's power. My lord, that is all right. But here, my lord, kindly see, here the same plot, the same ward number, just because there was a building, the rate was 165. My lord, that went in and became 0.50 based on the circular, which was also relied in the earlier order, which was also accepted by them. They did not challenge. It is just holding. Now, my lord, instead, what they now do is that since we had, my lord, I'll take your lordship to my appeal also, because that will clarify the entire stand. My lord, that we have done it. Kindly comes to our memo. We had offered, my lord, this amount of this calculation, taking it and holding it at rupees 1 per square feet. So based on that, my lord, they actually proceeded and the tribunal held that since this is a higher rate which has been projected, so it should be that.
I understand.
That is at page 63, my lord, is my prayer in the appeal. My lord, that is what we had said, we had specified, my lord, the valuation which the lordship will find in my impugned order dated 8th November 2017. My lord, that valuation, the first paragraph already notes, it was taken into account. Kindly turns to page 63. So see, this is what we had basically offered. Now, since we had already proposed a higher sum, the tribunal was not inclined to interfere with the proposal and go for something lesser than that. So it went ahead to pass that only, and that is what was assessed to be the one of every quarter. Well, that is how it was. So what I submit, I beseech your lordship, my lord, going by Taylor versus Taylor, your lordship is already aware of, then also Nazir Ahmad, my lord, wherein it was specifically held that yes, if the statute is defining a purpose to be done in a specific manner, that has to be followed. My lord, I am basically beseeching your lordship to my contention on the proposition of law that by virtue of the effect of section 190 of the KMC, my lord, already this has become a finality. The assessment has reached finality. If your lordship kindly takes the trouble to come to 190, my lord, 190 of the KMC Act.
Section.
Yes, section 190, the final valuation. So, my lord, this has already become a final valuation. The 90 days period has expired. Thereafter, my lord, an infinite time has expired. Now, when we chose to actually ring the bell, they found that this is a good option. So, since the matter is already pending before this High Court, why not avail this chance and come up with a revisional application? So, my lord, this is nothing but an afterthought. Whatever it is, but even if we take it as an afterthought or barred by limitation or whatever, but I am not into it, because by virtue of their conduct itself and in view of the proposition which is already set out with respect to the interpretation in Taylor versus Taylor as well as Nazir Ahmad, my lord, the final valuation which is espoused under section 190 of the Kolkata Municipal Corporation, my lord, is already there. It is there, accepted by them, because that is the reason why they chose to sit over it. And it is not one day, it is basically 2017, and they have come up before this court in 2021. Sometimes I'm just checking the date on which was affirmed. My lord, 9th March 2022. I'm sorry, my lord, it was not 2021. The number initially was 2021, but it was affirmed, my lord, in March 2022. Kindly see page 11. 9th March 2022. That means 2018, 19, 20, 21, 22.
No, it was 24th November 2020.
2021. Well, oh, I'm sorry, Malad. This is my affidavit which I put. Yes, Malad. 24th November 2021. So, my lord, the order.
You are referring the civil revision, no?
Yes, Malad.
Yes.
I am sorry, it's my mistake, Malad. I was just
No, sir.
looking at my affidavit,
No,
Malad,
sir.
because since I was placing for my affidavit in opposition, so that was affirmed in March 2022. 24th November 2021 was the date on which it was filed. So my lord, I would just sum up in threefold manners. One is that, my lord, with respect to this, the applicability or the reference of that order was not bad, because it was more fully referring to the mode in which it was calculated, and the circular which was relied on in that judgment is also applicable here, because they have neither challenged the validity of that notification or circular issued by the mayor, the then mayor, and nor did they propose to actually challenge that particular order wherein an annual valuation of a premises in that entire premises area of 21 Potteries Road, my lord, was fixed. So they have not done that. They chose not to really disturb on that. Instead, what, my lord, they say today that this is not applicable here only by virtue of one thing, and that one thing is, my lord, that this is a 5-story which cannot have a replicate over a place which is absolutely vacant land. But, my lord, here the vacant land is a vacant land, and hence, my lord, it was counted in the equation as per that particular circular, my lord, as 0.50. But since we had opted for giving a higher rate, that was taken in, and instead of that 36,000 which was coming as per the equation, my lord, they have given a 73,000 annual valuation, which is absolutely the double of the amount which was otherwise coming to if we go by the calculation. Now, my lord, that is one part of it. Now, if we say so, then again we are again coming back to the statute, because this is the statute which had basically come and taken the entire assessment process, because the procedure is laid down in the statute itself. We are bound by Kolkata Municipal Corporation Act when it comes to assessment. Now, when we come to that, immediately, my lord, as my learned friend is saying, that you cannot go beyond the provisions of Kolkata Municipal Corporation Act. Similarly, my lord, here again 189 10A comes in because they have not chosen to go, and even because they were present. It's not that they were not present, it was uncontested, they were not aware of, no notice was given to them. I would have taken it. But here, my lord, they were present, they had argued, they had made their submission, and they were well aware even on the date of the passing of that order. So they chose to sit over it because they knew that this is what it is. And now when we came up that let this change of name be recorded and let the demand be issued, they come up, my lord, and they say that this is something where we want to really assel that order, and hence in 2021 in the month of November they came up, but by that time, my lord, again 190 has reached its finality. My lord, this is the crux of the case. My lord, I'm just handing over Nazir Ahmad, my lord, just for your lordship reference. Within that, my lord, it is Manupatra. My lord, it is of Manupatra, my lord. I hope your lordship won't mind. My lord, the contentions, my lord, paragraph 12 is very clear. Kindly take a note of paragraph 12. My lord, actually citation, if your lordship kindly records, is of AIR 1936 Privy Council 253, because that is holding the field.
AIR?
AIR 1936 Privy Council.
Page?
253. My lord, this is the one celebrated judgment which is holding its field after it is deriving its reference from Taylor versus Taylor. That is of, my lord, also referred here. Chancery Division had decided on that.
Paragraph?
My lord, paragraph 12. Paragraph 12 from middle, if I may read, the rule which applies is different and not less recognized rule. Only that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Well, this is the one which we actually rely on when we think of this proposition of interpretation. So I really wanted to cite this before your lordship to take it into account. My lord, I rest my submissions here. My lord, only that, just for your lordship's convenience, my lord, I'm handing over a list of dates which will give you a bird's eye view as to what happened on which day. My lord, my faith of the writ will be dependent on this. So, my lord, I am really not arguing on the
No,
writ.
no, no, not at all.
We shall do it, my lord, after this is passed. My lord, may I take your lordship's view?
Yes, sure, sure. Yes, take down.
Well, may I, is it?
Not required, not required. Mr. Ghosh, please listen to my order.
Get full permission.
Both in Dismissed.
But Your Lordship, remanding the matter back, my lord, in a way, my lord, that once we go to the calculation which has been made by the hearing officer, it may dispose subject to your lordship or what my lord says, then that could be upheld instead of sending and considering in that light of, because the calculation is there.
No, no, no. Let him allow it.
My lord.
I'm directing the appeal to be considered in accordance with that law.
My lord, may I just mention, my lord, the next matter, item number 2, my lord. My lord, may it appear on 31st, my lord, instead of next Friday, my lord, I'm in some difficulty. Appear for the petitioner in item number 2, my lord.
Tell me
Instead of-
when the matter can be.
My lord, after a fortnight hence, my lord. Only next Friday, my lord, I'm in some difficulty. 31st, my lord, is on Friday after that, so it can appear on 31st, my lord.
Today is 17.
My lord.
So can it be taken off 31st?
My lord.
लिखे नहीं तो भाई on not लिखे नहीं. As per request made at the bar. As per request made at the bar. As per request made at the bar, let the matter be listed on January 31, 2025 under the same heading.
I am so grateful.